Court does call the case of People versus Robert Greenshields.
Good morning, Roger Cohen on behalf of Mr. Greenshield. Mr. Greenshield, would you state your name for the record?
Robert Claude Greenshields.
Thank you, sir.
Judge, Mr. Greenshield's in, it's my understanding in Oswego County Jail. I need to have further contact with him. The prosecutor's offered me a misdemeanor. Unfortunately, we can't do a Zoom breakout room, so I would ask if the court would give me a 3-week adjournment so I can speak with him.
I don't know if that was a request or whining, whichever it was.
It was probably whining.
He was whining. Okay. You do it very well.
Mr. Greenshields, are you still going to be in the jail in 3 weeks?
I have sentencing on October 9th.
So
Okay. All right. Thank you.
All right. Probable cause conference will be adjourned to September 25th, 2025, 9 a.m. Bond continued.
Thank you, Mr. Greenshields. I will get a hold of you. Okay.
Okay, thank you, sir.
All right. Thanks, Judge.
Thank you, sir. Court calls the case People versus Evan Sherbert.
Morning, Honor. Raymond.
Sure, Matt.
Morning, Judge. Brian Bowling on behalf of Mr. Sherbert. Evan, can you state your name for the record, please?
And Sherbert.
Your Honor, I'm asking for an adjournment. I did meet with Mr. Sherbert via Zoom yesterday at the Livingston County Jail, and we just need to complete discovery.
Probable cause conference September 25th, 2025, 9 a.m. Bond continued.
Your Honor, may I address one issue regarding bond?
Sure.
He currently has a personal bond on this case.
Got it.
With the court amended to a nominal cash bond.
Bond will be set in the amount of $1,000, 10%.
Thank you, Judge.
Court calls case of People versus Stephanie Cleaver.
Good morning, Honor. Charlotte Steffen on behalf of Ms. Cleaver. Good morning.
Your name?
Stephanie Cleaver.
All right. What are we doing?
Your Honor, we are adjourning the PCC. I have discussed with Ms. Cleaver her right to the exam within 21 days. She wishes to waive that right. And the reason is for discovery, Your Honor. I just got appointed 2 days ago.
All right. 25th work for you?
Yes, it does, Judge.
Probable cause conference September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Jeremy Anderson.
Morning, Honor. Sam Bernstein with and on behalf of Mr. Anderson. Your name for the court, Jeremy?
Jeremy Anderson.
All right.
Your Honor, we are prepared to continue to exam.
Discovery is complete.
Yes, Your Honor.
All right. What date are we on? 16. People had their witnesses available the 16th.
Yes, Your Honor.
Preliminary examination in person, September 16th, 2025, 9 a.m. That is before Judge Washington.
All right.
Bond will continue.
Thank you, Your Honor.
Calls case of the People versus Frankie Hewling.
Good morning again, Sam Bernstein with and on behalf of Ms. Hewling.
Frankie Healing.
Thank you.
Asking for an adjournment for resolution, Your Honor.
Probable cause conference in this matter will be adjourned to hold form. September 25th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Let's call the case People versus David Epps. I'm done with my outsides.
Good morning, Judge. Christopher Quinn appearing on behalf of Mr. Epps.
Morning. Your name?
David Epps.
Thank you.
Mr. Epps is requesting an examination, Judge.
Discovery is complete. Is discovery complete?
Yes, Judge.
People had their witnesses available to 16.
Yes, sir.
preliminary examination in person, September 16th, 2025, 9 a.m. That is before Judge Perry.
Thank you, Judge.
Bond will continue. Thank you. Court calls the case of the people versus Donovan Friel.
Assistant Public Defender Jay Bellinger on behalf of Mr. Friel, who appears via Zoom. Mr. Friel, can you please state your name for the record?
Donovan Friel.
And Your Honor, we are seeking to adjourn this for possible media discovery on this matter. I'm not currently in receipt of any.
Mr. Friel has private attorney, Mr. Sam Bennett.
Oh. Does he?
Do I have a substitute?
I don't have one.
This has got other counsel, but I have not signed the substitution.
And Your Honor, I was not aware of other counsel myself.
Who's the attorney?
It's Mr. Sam Bennett. He's in the room close to the chat.
Mr. Bennett?
Yes, good morning, Your Honor. Sorry about that. And
Are you representing Mr. Friel?
I am, Your Honor. Yes, we sent in a substitution yesterday. And Mr. Bellinger.
Was it signed off by the PDs?
It wasn't yet. We are just retained yesterday, so it was kind of a rush.
Where'd you send it? Because I don't have it.
We sent it to the public defender office waiting for a signature.
So the real answer to that is no, he's not representing him today. You're requesting an adjournment?
Yes, Your Honor. It sounds like Mr. Bennett would need that anyway, so.
Yes, that is correct, Your Honor.
September 25th, 2025, 9 a.m. Bond continues.
Your
Thank
Honor,
you.
Your Honor, given that I'm on the case or will be on the case shortly, could we do the following week, please, the 2nd, just to make sure that I don't have a conflict?
October 2nd.
October 2nd is not.
Thank you, Judge. And we'll get to that.
Hold on a second. Hold it. What?
Either Tuesday the 30th or October.
Oh. September 30th. That's a Tuesday, 2025 at 9 a.m.
That sounds good, Judge. Thank you.
Thank you.
And then, Your Honor, very briefly, Mr. Friel would like to travel to Indiana in the next few
Then he
days.
can tell his attorney on the case, and then I will consider his request.
Okay, thank you,
I
Judge.
need the substitution before you start talking on his case.
I understand, Your Honor.
Thank you. Court calls the case of the people versus Andrew Gendy. Pardon? Mr. Fanta?
Good morning, Your Honor. Andrew Fanta on behalf of and with Mr. Gandy.
Your name, sir?
Your Honor, Ms. Douglas and I talked about this case, and she didn't know whether she would be able to fully discuss the parameters of the case before today's PCC meeting. Accordingly, I would ask for an adjournment to September 25th at 9 o'clock.
Well, I'll put it down. Any objection from the people? September 25th, 2025, 9 a.m.
Your Honor, if I may, Your Honor, if I could address an ancillary issue on the 29th of August, Mr. Gendy was arrested at home in the early hours of the morning for a violation concerning his tether. He had previously called 3 times, and his sister called once to the tether folks that there was something wrong with the tether. Accordingly, I would ask if you would release him from jail on a $5,000 personal recognizance bond until the 25th of September. I have personally known the family for over 25 years. Thank you, Your Honor.
That is not the information that we have. There were sirens and alerts going on. They were trying to contact him directly and were unable to get through to him. So I don't know where these contacts were coming from. And then they found the defendant was placed in custody. So certainly you would be entitled to a hearing on that, but I don't have anything other than that information. So if you'd like a hearing, you can certainly motion that up and I'll be more than happy to hear it, but I'm not going to change his bond at this time. Motion for bond reduction or change in bond is denied at this time. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus, is it Centassia Callaway?
Then on behalf of the people, Your Honor.
Jacob, on behalf of Ms. Callaway, Judge, would you state your name?
Natasha Calloway.
Judge, I met with my client. She would like to pursue the matter through a preliminary exam. Judge, I'm wondering, I probably sound like I'm
Is
whining.
discovery complete?
Yes, Judge. Is it possible we can make it out to September 30th?
Anything's possible.
Well, I know with you, Judge, it is.
Well,
I got a few more cases coming up. I'll be whining.
what'd you say?
Nothing. You're a great judge. That's what I said.
What did he say?
Judge, we have a big docket. We should move along.
People have their witnesses available the 30th.
We'll do our best, Your Honor.
All right. Preliminary exam. Will that date work for you, Mr. Kilwall?
That's the date I asked for. Thank you very much.
That was the date you asked for?
Yeah. Thank you for your
I
very
don't know why I'm
considerate.
doing it. Preliminary examination in person, September 30th, 2025. That's, geez, Mr. Kilwall, we'll see each other again. That's
At 12, Judge, you're very
before
considerate this
me.
morning. You're very considerate this morning. Thank you. So we're
Bond will continue. Does he have any more? Oh. Court calls the case, people versus Brent. Is it Hackbarth?
And then on behalf of the people.
Morning, Your Honor. Dan Garrett on behalf of Mr. Hackbarth. He's stepping forward. You take your name to the judge.
Brent Hackbarth. Thank you.
Your Honor, we're asking for an exam. Discovery is complete.
People have their witnesses available the 16th.
We'll do our best, Your Honor.
Preliminary examination in person will be set September 16th, 2025, 9 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Come up and see you. Okay.
Court does call the case of the people versus Sean Edgar.
Edgar. Morning, Rob J. Kilwell on behalf of Mr. Edgar. Judge, I was just appointed late yesterday afternoon. I don't have any contact information because I was appointed so late. But I would ask the court, respectfully ask the court if it would grant a 2-week adjournment.
All right. Well, he also has a violation. He's not reported to community corrections. So
I got
when
that.
issue bench warrants on both cases. Bond is setting him out at $25,000 cash surety. Those warrants will issue immediately.
When will they kick in? Now?
As soon as they get to my clerks, they're going in.
Would the court consider maybe, no?
No.
I've used up my.
All right, thank you. Just trying to move it along, Mr. Pillowall. Court calls the case, people versus David Rasmussen.
And then on behalf of the people.
Just following your advice.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Rasmussen, who approaches the podium.
Your name, sir?
David Rasmussen.
All right, what are we doing?
Your Honor, discovery in this case is complete except for the 911 calls. I've spoken with the prosecution. Those are already been ordered. We're asking the court to set this for an exam, please.
Your Honor, it should be involved before the exam meeting.
All right. I'll mark that if they're not in, you would not be entitled to an adjournment based upon not having those, but people have their witnesses available the 16th.
We'll do our best, Your Honor.
Preliminary examination will be set September 16th, 2025, 9 a.m. That's before
Judge Perry.
Judge Perry.
Thank you, Your Honor.
Bond will continue.
Your Honor, may I address bond?
Briefly.
Your Honor, Mr. Rasmussen is a general contractor, self-employed. He's been in custody for some time now. We understand these charges are somewhat serious. However, reading through the discovery, I think that a personal recognizance bond with a no contact order would be appropriate in this matter. He's not to go to the address where the complainant is living. And he just wants to try and get back to work. This is his busiest time of the year with painting and getting people ready for the winter. And quite frankly, his 1987 pickup truck's in impound anyway. He's not a man of means, Your Honor. So $2,500 may as well be $250,000 to this man.
Respond.
Object any modification of bond. In this case, defendant was angry at the victim because he thought she was sleeping with someone else. He then pushed her on the bed and strangled her with 2 hands. He later punched her in the face, and she had bruising around her eye. He also took her phone so she couldn't call 911. And when officers asked her about the strangulation incident, she said it's happened previously 4 times in the last month, and he always uses both hands and tries to make her pass out. So I have great concerns for her safety. I would also ask for, if he is released at some point, I was not sure if the tether was ordered, a GPS tether. For address, I would like that also be ordered, but it's just how I reject any modification of bond.
It looks to me like it was ordered stuff. Anything else, counsel?
Your Honor, I don't want to get into the merits of the case, but the same report also indicates that the victim was the first to be arrested till she changed her story and they decided to issue the warrant against my client. Additionally, she indicates she doesn't want to prosecute my client. So we can read the report or we can read the whole report, Your Honor. I don't believe he's a danger to the community at large. He has a very minimal record of one operating while impaired, I believe 7 years ago. I don't believe he's a danger to the community. He's a homeowner in Ann Arbor. He's lived here his whole life. He's 56 years old. He just had his birthday in jail over Labor Day. We're just trying to get him back out so he can work, because otherwise he's probably even going to lose his truck if he can't pay the impound fees on that. And again, we're talking about a 1987 pickup, Your Honor. We're not talking about a very wealthy man. He was willed the deed to the house from his mother, and he lives in his family home.
Well, at this time, based upon the information that's in front of me, I'm not going to change the bond. I wouldn't find that the magistrate setting a bond would be an abuse of discretion. So motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case People versus Isaac Sepulveda.
Morning, Your Honor. Jake Hill on behalf of Mr. Sepulveda. Did you state your name?
Isaac Sepulveda.
Judge, I've met with this young man. He wants to proceed through a preliminary exam. Discovery is complete. I would, with some trepidation, ask the court if we could do it for September 30th again.
Want so bad to say no.
Well, you being the considerate, kind judge you are.
September 30th. Will people have their witnesses available? I guess I should ask.
We'll do our best, Joe.
All right. September 30th, 2025, 9 a.m. That is before Judge Washington.
Thanks. We'll talk.
Bond will continue.
Thank you, Judge.
Court calls the case People versus Annie Oglesby.
Good morning, Your Honor. Bells for the people.
Where is she? Oh. Here, I thought she had enough yesterday.
Never. Never.
Your name, ma'am?
Annie Murray Oglesby.
Good morning, Your Honor. Tina Saxon for Miss Oglesby.
Okay, she's in. Got it. All right, thank you. All right. What are we doing?
Your Honor, there are now 2 cases. I just received
Yes.
the newest case yesterday. I don't have any discovery for that, but I did file my appearance and request for discovery yesterday. For the first case on this matter, I'm going to ask for an adjournment because there's an overlap between the two cases. It looks like it's coming out of two different jurisdictions, but for the same offense. So I'm asking for an adjournment so that we can track these together if the court is in agreement with that.
Yes, I will adjourn it. Currently, she's being, okay. Probable cause conference will be adjourned September 11th, 2025, 9 a.m.
Your Honor, since this matter, I have to ask for another date. I will be out of state, returning that day, but.
I can do the 18th. Will that work?
Yes.
September 18th, 2025, 9 a.m.
Your Honor,
Bond
when
will continue.
appropriate, I'm sorry, there was a bond violation that.
Yes,
we
there
needed to-
was. Pardon?
Your Honor, as you remember, on the first violation, Ms. Oglesby was in custody. The second one, she simply did not have the money. She had lost her job while she was in custody in the other jail. And she couldn't pay for it, therefore they would not allow her to test. And now she's in custody again.
She didn't report for intake. So I don't know how that happened.
She stated that she called and left 2 messages with the community health and never received a phone call back.
Well, my understanding is she didn't report. We sent over another order. She again did not report for intake or testing.
Again, yeah, she lives in Jackson, which I stated at the
Okay,
first.
that's like 35, 40 minutes away. And she didn't report twice.
She could not report the first time, Your Honor. She was in jail.
I was in custody in Eaton County.
Right.
So I understand your position, at least on the second time. She did not report for intake or test. I'm just providing the explanation for the failure to test. It's not free and they would not do it without it, but I understand your position on the intake.
It's considered a dirty job in Jackson if you don't have the money.
I don't know what that has to do with this. You didn't report to our community correction.
Ms. Oglesby, don't speak.
All right, I don't need a response. Motion for bond reduction is denied. Bond will continue. Thank you. Court calls case People versus Jeremiah Dillian.
Trevor Maybell for the people, Your Honor.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Dillon, who stands to my right.
Your name?
Jeremiah Dillon.
Your Honor, I was just appointed yesterday. I believe the people have withdrawn. Hopefully the court has the order and I filed my appearance. I did get the discovery in this matter, but I just met Mr. Dillon this morning in person. So we're asking for a 2-week adjournment to discuss the matter with the people.
Probable cause conference September 18, 2025, 9 a.m. Bond continue.
Thank you very much, Your Honor.
Court calls case People versus Vincent Dunlap.
Trevor Maybell for the people, Your Honor.
Good morning, Your Honor. Laura Yagi, Assistant Public Defender, with on behalf of Mr. Dunlap, who's approaching. Mr. Dunlap, could you state your name for the court?
Vincent Ever Dunlap. Thank you.
Your Honor, I apologize, but may we approach in this matter?
Yes.
Thank you. Thank you, Your Honor, for the bench conference. As I mentioned, I know Mr. Dunlap is eager for me to make a bond argument for his release. He was in treatment. I don't have that documentation. I'm going to follow up to try to get it. I obviously want to advocate for his release, but I know it's important to have the documentation verifying what he's saying, which is that he did actually complete the treatment.
I have another copy at the house.
So I'll follow up with Mr. Dunlap about that. In terms of the PCC, Your Honor, at this time, a prosecuting attorney and I have had some communication. There's no offer at this time, so we would ask that it be set for exam.
Discovery is complete.
To my knowledge, Your Honor.
People have their witnesses available on the 16th.
Yes, Your Honor.
Preliminary examination in person, September 16th, 2025. 9 a.m. That is before Judge Washington. At this time, bond will continue.
Thank you, Your Honor.
Court does call the case People versus Larry Atkins.
Calls for people.
I know, because she's not here. Your name, sir?
Larry D. Atkins.
Thank you. Where is Akinruli?
We're grabbing it right now, Your Honor.
Not forcefully enough.
Understood.
No, take your time.
Apologize. Assistant Public Defender, Chinazi really, Your Honor, on behalf of Mr. Larry Atkins. Mr. Atkins, have you already stated your name for the record?
Yes.
Okay. Your Honor, we are asking.
His whole story of his life by the time you got here, but go
I was
ahead.
gone that long. I'm sorry, Judge. We are asking for an adjournment in this matter to gather mitigation information.
You have a green sheet.
I do, Your Honor.
You're filling it out now?
I am, Your Honor.
Yeah. Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Bond continue. Slow.
Thank you, Judge.
Thank you.
Thank you, this.
Court calls case People versus Jakeeves Gully.
People, Your Honor.
Apologies. Laura Yagi, Assistant Public Defender with and on behalf of Mr. Gully. Mr. Gully, can you state your name for the court?
Jakeeves Gully.
Thank you.
I apologize, Your Honor. We're asking for an adjournment. Mr. Gully indicated he's going to retain counsel or he's in the process of retaining counsel.
How long is that going to take you?
2 weeks.
One adjournment for that purpose. Probable cause conference, September 18th, 2025, 9 a.m. Bond continue.
Thank you.
Court calls case People versus Jamie Bailey.
Laura Yagi, Assistant Public Defender with and on behalf of Mr. Bailey. Mr. Bailey. Your Honor, I was going to request an adjournment. I have a green sheet. We did receive media discovery yesterday, and I haven't had time to review it with Mr. Bailey, so.
Because he's not here.
Apparently is not.
That warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000 cash surety. That warrant will issue immediately. Yeah. Court does call the cases of the People versus Demond Harris.
Hello, Judge Brian Bowling on behalf of Mr. Harris, who's approaching. Your name for the record.
Harris.
Judge, I'm asking for an adjournment so that we can have some ongoing plea discussions in this matter.
Is this the only thing holding him, or?
No, there is other matters, Judge.
All right. Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Court calls case People versus Christopher Minor. Custody.
Good morning.
Mabel for the people around.
Good morning, Your Honor. Kerma Dadush on behalf of Mr. Minor. Mr. Minor, are you able to sit down on the chair?
Yeah.
Yeah, could you? I asked the wrong question. Thank you. Can you state your name for the record, please?
Minor.
Did you need his full name, Your Honor?
That's Mr. Minor. We'll go.
All right. We still have outstanding discovery, Your Honor. We were going to ask for an adjournment, please.
All right. Is this the only thing holding him?
No, it's not.
Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
All right. Thank you, Mr. Minor. Let's call the case people versus Dominique Kelly Payne. Dominic.
Assistant Public Defender Jay Bellinger on behalf of Mr. Kelly Payne, who approaches, Your Honor. Take your name for record.
Dominic Kelly Payne.
And Your Honor, I have supplied the court with a waiver form.
Yes. Sir, you're waiving your right to a preliminary examination?
Yes.
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 You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 through 3 with 4 following.
Your Honor, people acknowledge, I'm sorry, not the people, defense acknowledges receipt of information, wait for open reading and stand mute.
Defendant having waived for reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
September 16th at 1:30 with Judge Cook.
September 16, 2025, 1:30, Judge Conkey.
Cool. That'll be me, okay?
Yep. Thank you.
Bond will continue.
Thank you, Your Honor.
Thank you. Let's call the case people versus Kayla Baird.
Assistant Public Defender Nazi Carey, really on behalf of Kayla Baird. Judge, can we pass this matter?
No.
Miss
Why?
Baird is present. I asked,
What?
she is here. I asked her to go to community corrections to test because she had not done so. So she's over at community corrections now.
She tested.
Downtown. She lives in Flint now. She's currently displaced and she tells me that she lives in Flint and she did not have a way to get down here to test. Thank you, Your Honor.
Court calls case people versus Melissa Konwinski.
Chelsea Virgils with and on behalf of Melissa Konwinski, who approaches. Please state your name.
Mary Konwinski.
All right. What are we doing?
Your Honor, we're asking to adjourn to continue a plea discussion, and I would ask to address bond.
Of course you would. Is this the only thing holding her?
Yes.
Probable cause conference will be adjourned September 18, 2025, 9 a.m. Yes, to bond.
Your Honor, we're asking for a personal bond in this case. I understand she did have a violation, but she has a thorough plan to maintain sobriety, including through CMH, full substance abuse and mental health treatment. She has an appointment set up with them already, including also the Vivitrol shots, involvement with her church. She goes to AA. She's really worried about getting out to work. She supports herself financially. And I think that this plan can set her up on the right track. So we ask you to consider that.
What is the plan? That's the plan?
Yes, treatment, AA, church. I think all of those things would be a great support system for her. And she did just get out of inpatient treatment recently. So that is fresh in her mind. She wants a chance to show the court that she will comply.
She got out and then 2 days later, she's violating her tether.
It was admittedly a relapse that she deeply regrets.
Response from the people.
Your Honor, we talked about this last week. I reminded the court that this was a hit and run with an alleged BAC of a 0.28. I'm not saying that someone's case, somebody that needs to see in jail indefinitely, I think I'd like to see it a little bit more concrete in any release with this grand tether.
Your Honor, may I respond briefly?
Go ahead.
I just wanted to point out that the incident allegation in this case was before her inpatient treatment, so she sought out that treatment herself. We have no objection to a scram tether, but I think that
Didn't
this,
she have a program for follow-up care after her treatment?
I believe so. I think that part of
Is
this
she
plan.
following that?
Are you following your plan?
Yes, I am.
And I think this is fairly
Oh.
concrete. She has an appointment on September 22nd.
After she got out of treatment, she was supposed to, there's another part of what her treatment would be. Did she continue with that?
What was the plan after treatment?
The plan after treatment was to go into IOP, which I did call CMH, but unfortunately, there was no opening until the 22nd, so I can have a 90-minute evaluation so I can get an IOP. I am still following up with Michael Francis, which is an outpatient psychiatrist in the meantime, until I can get in there on the 22nd.
So the answer to my question is no, she didn't follow up with that. And then secondly, then again, 2 days after that, outside of the facts of the particular case, she was drinking again. So, and I'm not really hearing a concrete plan that's consistent with the inpatient that she received. So for those reasons, the court is going to deny the request for a bond. In this case, bond will continue. Court does call the case of the people versus Jennifer Baker.
Special for the people.
Assistant Public Defender Jay Bellinger on behalf of Ms. Baker, who approaches, Your Honor. Baker, can you please state your name for the record?
Jennifer Baker.
Yes, you may. Probable cause conference will be adjourned to September 11th, 2025, 9 a.m. Bond continued.
I had to come back a third time.
No, and Your Honor, I just want to make clear on the record for Ms. Baker's purpose that if this case is dismissed, in fact, and I talked to the prosecution about that, you will not have to come back
Okay.
for the dismissal to issue.
Okay.
Okay? Is that correct, Your Honor? I just want to make sure that.
Sure.
Okay.
No, she doesn't have to come back
Okay.
because of the reason why there would be the dismissal. I wouldn't want to. All right.
Okay.
Thank you.
Okay.
So we will figure it out. Okay.
Oh.
All right.
Court does call the case, people versus Demarion Mikowski Smith.
Morning, Your Honor, Raymond Cook for the people.
Judge Calabrell on behalf of Demarion Mikowski Smith.
Assistant Public Defender Alexis Zerbs, also with and on behalf Mr. Mikowski Smith.
Good morning, Your Honor. Demarion Cortez Mikowski Smith.
All right. What are we doing?
Your Honor, there should be a green sheet submitted. We are respectfully requesting an adjournment just to discuss his options with him. And to this.
Are these the only things holding him?
Your Honor, if we can make a minor request, he's currently awaiting an MDOC tether for a circuit court case that he's on probation for a home confinement tether. He saw the visiting judge for Judge Conlon yesterday. He turned himself into the jail yesterday morning on that warrant, got that violation taken care of. They granted him the PR with the MDOC tether with home confinement. So we would be asking if the court would consider removing his tether for his bond on the CCW case, considering he'll already be monitored with the MDOC tether.
But we will get that information.
And that's what I was explaining to him, Your Honor. We just would make that request because it does seem a little redundant that he's going to be home confined twice.
And Your Honor, if I may add, Mr. Mikowski Smith has been very communicative with me during my course of his representation. As soon as he was instructed to turn himself in, he called me immediately to let me know what he was doing and that he was about to turn himself in. So he's been very communicative, and I've every confidence that the court will be able to.
He's got 2 legs, so we can put a tether on each one.
Understood.
Is that right? I mean, I'm just saying,
That's what it have to be. That's what it have to be, Your Honor.
And understood, Your Honor. I did have that conversation with him as well.
If we can get communication from MDOC, I don't mind releasing ours, but I'm not going to release our tether until I
Until
have that assurance that we'd have the information.
Understood, Your Honor. We can see if that is a possibility.
All right, so that request regarding modification of bond at this time it's denied, but if they get that information, then we'll figure it out. Okay? Thank you. Oh, it's the 18th.
Thank you, Your Honor.
Court does call the case People versus Taiwan felon.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Phelan. Hearing via Zoom. Mr. Phelan, will you state your name for the record?
I want Phelan.
Thank you, sir.
Your Honor, may we approach?
Yes.
For that bench conference, we are asking for an adjournment on Mr. Phelan's case for some continued plea negotiations.
All right. Probable cause conference will be adjourned the September 18th, 2025, 9 a.m. Will that be enough time?
I think so.
All right.
Thank you.
Bond will continue. Court does call the case People versus Melvin Morrow.
And Laura Yaki, Assistant Public Defender, with and on behalf of Mr. Morrow, who's approaching. Would you state your name for the court?
Melvin Morrow.
Your Honor, I apologize. I do have two documents, one signed exam waiver and one request that Mr. Morrow be released to treatment. I did provide a copy to the prosecutor.
I would allow him to release to treatment.
Thank you, Your Honor.
He's waiving exam.
Yes, Your Honor.
That's correct, sir?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Ms. Young.
We waive formal reading and stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
September 16th at 1:30.
September 16, 2025, 1:30 before Judge Conkey. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Dominic Brewer.
Trevor Maybell for the people, Your Honor.
And with that, on behalf of Mr. Brewer, who is here with me, can you please state your name for the record?
Dominic Brewer. Thank you.
Your Honor, we're asking for a 3-week adjournment so we can continue plea negotiations.
3 weeks?
Yes, if Your Honor is so inclined.
3 weeks?
Oh.
Why?
Because I'm on vacation and he has requested that.
So we
Uh-huh.
all have to wait for you to get back?
No, I can do my work before my vacation
You're gonna do it before the vacation, then why am I giving 3 weeks?
because it's unrealistic that I complete what I need to do for his case before my vacation starts. Your Honor, I have full faith in my PD team that if it gets adjourned 2 weeks, that they'll do even better than I would on his case. But I'm just trying to get his
that's
request in. Yeah.
I know where she.
Into a bench conference.
September 25th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thanks, Mr. Brewer. Take care. Court does call the case People versus Megan Moses.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Moses, who approaches to my right. Ms. Moses, please state your name for the record.
Megan Moses.
Your Honor, today is the date time set for probable cause conference.
It is.
At this time, there was an agreement in place. So we're going to be asking for an adjournment of this probable cause conference and some consideration on bond later on.
Okay. How much time did you need?
Let's start with 3 weeks for the adjournment.
Okay.
All right. We're going to go into the bond.
Yes, go ahead.
So, Ms. Moses, I believe she was here last week. She had turned herself in. She had issues both with her tether, being able to get a Zoom date. When she appeared here, there was a question about whether or not she had communicated with our office or with anyone concerning the issues she was having. The attorney who was standing in at the time, I don't think was able to let the court know that Ms. Megan had in fact been in contact with her. She let us know. She did let us know that she had issues. We have file information from August 20th where she contacted us concerning the issues she was having concerning her phone and her tether. So I understand that one of the things that the court was concerned about was that she did not have communication with us. And that's just not the case. She did communication with us. There are file notes that indicate that she did contact her office. More importantly, she did turn herself in. She came into her court date. She was here. She was present. So what we're asking is that not only that she be released from jail during this interim period, because part of what we're trying to do is to get her in a situation where she can pay restitution for this matter without giving away too much. So we want to be able to get her out, get her employed, and get her to making payments. And so that comes to the second part of what we're here to ask.
What day did she turn herself in?
Last Thursday. And she came here, she came to court and then she was taken into custody. She was remanded when she came to court. So she came here.
With the tethers.
Okay. Because I think I did address most of that yesterday with the last time that we were here, but response from the people.
Your Honor, ultimately it'll be up to the court's discretion. I can't say what communication she had with her attorney. Obviously, I'm not privy to that. My concern is I do think that she does need to be out in order to make that restitution payment. That is sort of the contingent basis of this plea negotiation. Whatever steps the court feels it needs to take in order to monitor her. I have no objection to that, but I think that some form of release might be appropriate given that we need to have that payment if you can't do that in custody.
Right, but the problem that I'm having is typically one of the forms of doing that is to put somebody on a tether.
Right.
Somewhere she's had a problem with the tether. I don't have any information that the tether was defective in any way. She said there was something with her bike.
Yeah, she was on the bike and somehow it hit.
And the other problem is that I'll say maybe she misspoke, but regarding the communication and where she was vis-a-vis her mother when she was last here, because she said one thing and then switched that and said another. So that was another issue that I had with the story she was telling me.
So I wasn't here, so I'm not privy to what that was about.
So what she said is she initially said she called her mom. However, prior to that, it indicated that her phone was broken. And so that she couldn't call. Then she abruptly changed and said she rode her bike to her mom's.
So what she's telling me is that she did call her mother after the phone was broken, but she did that at a gas station. She had to ride someplace.
Where?
At a gas station.
It was a Walgreens, actually.
Walgreens gas station. So she had to go someplace.
So last time the story was told, we didn't have a stop at Walgreens.
It was a lot going on.
Yeah, apparently.
The story and I was nervous. So I was saying I called my mom and then I rode my bike, but it came out as I was misspeaking, but it was all together. I did call my mom as
and then rode my bike to her work.
So
But it was at a gas station. It wasn't on my cell phone or anything.
Is that a gas station?
It was a gas
I thought it
station.
was a Walgreens.
Well, there was a Walgreens next to it, but there was a gas station Walgreens. It was like right there in Jackson on West Ave.
Didn't she just tell me she called from a Walgreens?
It was a gas station Walgreens, like right there. Honestly, it was the Walgreens phone that I used.
At the gas station?
No, there's a gas station next to it. So it was, they're both, it's the same building.
should we Google Mr. Jackson?
I'm not Googling anything. But
I'm just saying, that's where I stopped to call my mother.
okay, so here's what I'm gonna do, because I either you have a problem telling a story
I'm not.
or
Sorry.
you're not telling me the truth. So what I'm gonna do is I will adjourn this 3 weeks, and that is to September 25th, 2025, 9 a.m. At this moment, I will have her bond continue. You've got a lot of people, Mr. Brown. So if somebody can show me a building where there's a gas station attached to a Walgreens that she's in that area,
They're not
I will then, they're not attached.
No.
Of course not, they're not.
We
Oh
will
my
Google it and we will have a picture sent right away to the court.
If you show me something that makes this story make sense, because this is now an added piece. She's at a drugstore calling. Who are you looking for? Who's gonna have to do it?
Oh, I'm gonna get one of our fine fellows.
I know, but which one? So that when it doesn't happen.
It was West Ave.
Oh, you guys get paid too much to do this. No.
It could have been a CVS. Honestly, I was-
Shanaza, you can't even appear for your case and now you're all in this. What? It's not it's a CVS? So it's not even a Walgreens.
I was in there was a lot going on, honestly.
I know.
I was in a panic, so I can't remember even where I called from. I'm pretty sure it was the Walgreens or CVS.
Okay, we're not gonna sit out here while you look at the computer. I've made my order. They can then, what?
The CVS right there, I think. Thank you.
Approach, prosecutor.
Show it to the prosecutor. Is it a Walgreens or is it a CVS? She doesn't even know what drugstore she's in.
Wait. This is not Jackson.
That's not where it
That's
is.
not even Jackson.
Yeah, I know.
Jackson, Michigan.
Right? They were gonna show me some fake Google pictures.
No.
No, I know what was gonna happen. Okay, I don't. All right, I've made my ruling. You guys can show this to me. She'll get released if I get a picture of the real place.
We got you, Judge. We're on it.
No AI, none of that, Mr. Brown. I know you don't even know what that is, so I'm not even, but I'm worried about them. Don't, Shanaza, get out of this case. What are you doing?
I'm looking at my case.
We got you. We got you, Shanaza.
MDOC. Up top, but I don't know who it is.
Oh,
Can you ask who it is?
there's an individual from MDOC, the Women's Huron Valley. Can you state what your name is? I think she's frozen. Appears to be who?
Miss Johnson.
Valerie Johnson.
Okay. So court does call the case People versus Valerie Johnson.
Morning again, Your Honor, Randy Cook, people.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Johnson. Ms. Johnson, will you state your name again for the record?
Valerie Johnson.
Thank you.
All right, I do have a plea form in front of me where she's going to plead to the charge, count 2 of use of a controlled substance, a 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
That is correct, Judge. And for the record, I did speak with Ms. Johnson this week. I did review the advice of rights form with her. She did give me permission to sign that as well as the plea form on her behalf.
All right, thank you. Johnson, can you raise your right hand, please?
Yes.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again for the record, please.
Valerie Johnson.
Okay, you can put your hand down. Ms. Johnson, it's this court's understanding that you're going to plead guilty to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form or went through that and gave your attorney permission. Is that correct?
Correct.
Did you have any questions regarding any of the rights on that form?
No.
Under paragraph 5, those are your trial rights. You understand that you'll be giving up those rights as well as all the rights that are contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
You on probation or parole? You're not.
No.
You're incarcerated. All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
On the date of September 26, 2023, at the Huron Valley Correctional Facility, did you have fentanyl in your possession?
Yes.
Had you used it?
Yes.
Did you know what you were using was fentanyl?
No, I thought it was heroin.
Okay, you thought it was some other drug. You thought it was
Yes.
heroin, but it was
Yes.
fentanyl. Is that correct?
Yes.
Okay. I think either way. it doesn't- Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Ma'am, is there anything you want to say before I do impose sentence?
Your Honor, if I may
No.
speak on Ms. Johnson's behalf?
Sure.
Your Honor, I did have a chance to speak with Ms. Johnson. This offense happened 2 years ago. At the time, she was grieving the loss of her mother, was unable to attend her mother's funeral. Since then, she has enrolled in treatment in the Michigan Department of Corrections and is currently on a MAP program. She does have her earliest parole date is not till 2033. So I'd ask the court to impose minimum fines and costs.
All right. I will impose $125 state fee, 365 days in jail, credit 365, sir. Thank you.
Thank you, Your Honor.
Good luck to you, Ms. Johnson.
Thank you.
Court does call the case, People versus Eric Buckner.
Laura Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Buckner, who approaches the podium. Mr. Buckner, state your name for the record.
Eric Buckner.
Thank you.
Your Honor, today's the date and time set for a probable cause conference. At this time, we are going to respectfully request that the matter be set for a preliminary examination.
Both cases.
Yes, please.
Discovery is complete on both cases.
Yes, sir. Best of our understanding, it is.
People have their witnesses available on 16.
Yes, sir.
Preliminary examination in person will be set September 16th, 2025, 9 a.m. That's before Judge Perry on both matters.
Thank you, Your Honor. May we address the issue of bond?
Okay. Go ahead.
Thank you, Your Honor. So the last time we were here, we wanted to make sure that Mr. Buckner could take care of both employment needs, maintenance needs, and hospital appointments. He had medical appointments. He's got an arm that is deteriorating. So he needs to be able to have MRIs. You tasked myself and the prosecutor to try to get together and work something out. At the time, we had indicated that for employment, he was doing deliveries, but he didn't have any hours. So he asked us to be together, work those out, and then provide an order to the court. We were unable to do that because up until recently, Mr. Buckman was unable to give us specific hours for the employment that he needed to do, for the deliveries. But you did say that as long as he let community corrections know when his appointments were, that he could go ahead and do that, and we put that in order. The development since then is that they told him that he cannot do the MRIs he needs to do with the tether on. Somehow that interferes. So what we're asking is for two things. First, that he be allowed to be able to remove the tether when he goes to do his medical appointments, so that they don't interfere with the MRIs that he needs to be able to do. Second, that he have 4 hours per day, either from 8 to 12 in the morning or from 1 to 5? 5 to 9. I'm sorry, 5 to 9, so that he can be employed. He has to be able to be employed. He's got a daughter that needs to maintain, a house that he needs to maintain. He's out on home confinement because the court obviously didn't feel he necessarily needed to be in jail. But if he's going to be out of jail, he's got to be able to maintain himself and his family. So we're asking not that you release him, not that you not have any oversight, but that he just be allowed to be out to be able to work while he's on home confinement, and that he be allowed to have substantive medical care.
Response from the people.
Your Honor, I don't want to get in the way of that. I just haven't seen any documentation related to it. I know that defense counsel states that he had previous conversations with the last prosecutor, at least as it relates to the medical. Certainly don't want to object to that. I'd ask for documentation related to employment prior to allowing that out there.
We did that numerous of times with reference. So what you sent me is a list of the hours that you need. But asking for something from there.
I've been on tele for a whole month, so we've been trying to figure this out. I don't know.
We don't be talking now. Because you're not talking so that the court can't hear us. So don't do that. So what they're asking for.
We're not going to have an issue with the medical, provided the appointment is provided.
Right.
The tether needs to be removed for that purpose. That can happen, and I'd sign an order to that effect. I'm still worried about this employment, giving him sort of this window to.
So,
oh, he's going to have that attitude when he just asked him to follow that instruction. Oh, we're not doing that. Motion for bond reduction is denied. I'm done. You talk to your client about why that just happened. My bailiff tells him something, he needs to just respond appropriately, not give that face. Oh, no, I'm done. Thank you.
thank you, Your Honor. We will have whatever sufficient orders the court needs.
Court calls the case, People versus D'Angelo Simmons. Better check himself and don't slam my door. Oh, is this Mr. Brown also?
Yes. Assistant Public Defender on behalf of Hannah Apple on behalf of Mr. Simmons. You say your name for the record?
D'Angelo Simmons.
Yeah. This is a competency.
Is the report back?
Yes,
Judge?
the report is
Okay.
back. It's in dated August 19. Don't know why. And it is finding that the defendant is competent to stand trial.
We would stipulate to that report, Your Honor.
All right. Court, having reviewed that report, would find the defendant is competent to stand trial, specifically that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. I do have an order that was submitted by Mr. Brown to that effect to the court, or proposed order. I'll sign that. Would you like this? Would you like this now set for?
Your Honor,
Oh, you're back.
Oh, hello.
No,
Lauren Brown,
It
Deputy
was
Chief.
more of a pleasure dealing with Apple, but go ahead.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Simmons. Your Honor, we are respectfully requesting this matter be set for probable cause conference so that we can have some kind of substantive conversation with our client.
Is this the only thing holding him or is he?
I believe. This is the only case.
Okay, so I'll set it for the 18th.
Thank you very much.
September 18th, 2025, 9 a.m. Bond continues.
Thank you.
You saw that. Court does call the case, People versus Dale Miller.
We're ready in that matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Miller, who appears by video. Mr. Miller, could you please state your name for the record?
Dale Joseph Miller, the Alpha and Omega.
Okay.
Your Honor, the reason we are here today is this was set for a probable cause conference. However, Mr. Miller is undergoing competency evaluation and other matters.
What? No, go ahead.
So
you guys gonna find out it's not so funny pretty soon.
I am informed of that.
Yes.
And we have, is there a competency order for this file?
Yes,
Yes, I do have it. All right, so what I will do
On
is
top
I
of
will
things.
order competency on this file. I will set it, I think those are set for November 6th.
Yes, so we'd ask Mr. Miller, just as we spoke, we're going to ask that this matter be joined with the other matters.
So I will set this for November 6th, 2005, 9 a.m. This time his bond will continue. Thank you.
Thank you very much, Your Honor.
Court calls case of the People versus Kevin Burton.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Burton, who approaches, Your Honor. Kevin Burton, sir.
Thank you.
And Your Honor, today we'll be entering a plea. I believe the court is in receipt of everything that it needs to have.
Let's see. Yes, I do.
And I apologize. There is a adjournment sheet there as well.
I have a plea form that indicates that the defendant would be pleading guilty to the charge of aggravated assault, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed, and that the prosecutor will be recommending to the sentencing judge, prosecutors deferred. That's the court's full understanding.
That is our full understanding as well, Your Honor.
All right, may I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Kevin Burton, sir.
Sir, it is this court's understanding that you're going to plead guilty to the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court cost. You
Yes, sir.
understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes, sir. Yes.
Plead guilty
Yes, sir.
to that charge. How do you plead?
Guilty, sir.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
All right, you signed an advice of rights form, is that correct?
My attorney has. I signed it with his permission, Your Honor.
All right.
Yes, sir.
You went through that advice of rights form, is that correct?
Yes, sir.
All right, you have any questions regarding any of those rights?
No, sir.
Please look at, there's a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights of the court.
I do.
You understand you're giving up your right to appeal, all right?
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
Yes. Or no. No, no one's promised me anything.
All right, let's get that straight. Has anybody promised you anything else other than what's been stated here today on the record to get you to plead to this charge?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Of my own free will, sir.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
On July 13, 2024, at the location of 3421 Platte Road, Apartment 12, City of Ann Arbor, Washtenaw County, State of Michigan, what did you do on that date involving an Angela Middleton that makes you think that you're guilty?
Threatened her, sir.
with a hammer, sir.
Okay, you had a hammer in your hand?
Yes, sir.
And you were in close proximity to her at that point?
Yes, sir.
And you threatened her with the hammer?
Yes, sir.
Did you say something that threatened her with the hammer?
Yes.
What'd you say?
Can't recall, but I said something threatening.
You said something that led her to believe that you would use that hammer
Yes, sir.
against her.
Yes, sir.
Would that be correct? All right. Either way. Sir, I would have to advise you that after I accept your plea and after that time, between that time and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and you also the court would not be bound by any sentence or agreement or evaluation. Do you understand that, sir?
I do.
Counsel, are there any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing in this matter will be
September 23rd at 9 a.m.
September 23rd, 2025, 9 a.m. That's before Judge Valvo. Bond will continue.
Thank you very much, Your Honor.
Court does call the case People versus Catherine Stiles.
Jackie, Assistant Public Defender, with and on behalf of Ms. Stiles, who is approaching.
Name?
Catherine Stiles.
Thank you.
And Your Honor, I do have a stipulation and proposed order for release to treatment for Ms. Stiles with the tether. The prosecuting attorney did indicate that she would stipulate if Ms. Stiles was released to treatment with the tether. Absolutely. Yes, sir.
All right.
Sorry, as to the substance of the PCC, I did not fill out a green sheet because Ms. Stiles wanted to request that this matter be continued to exam. However, and when I inquired yesterday, I think there wasn't media discovery. There may or may not still be outstanding discovery. So that's where we're at.
So our office did request the police on August 27th video. They hadn't provided it to us, and they've not provided us any video. But there was an officer who responded to a store, and so I'm just going to confirm that there's no video there. But we did ask.
All right. You would not be entitled to an adjournment if that existed not. You understand that, ma'am, if you want to proceed to exam?
Because the prosecuting attorney has given us all the discovery they have, if there's something else, we can't ask to adjourn it because at this time we're saying that that's all they have. Does that make sense?
Yeah, absolutely.
People have their witnesses available to 16. Preliminary examination will be set September 16th, 2025. Judge Washington. Bond will continue.
Thank you, Ron. Thank you.
Whoa. This is. Where's the gas? This is the gas station? That's the part. They're not attached.
Your Honor.
There's a road in between.
She's my
like a big road.
My client is not as eloquent as you, Your Honor, when it comes to describing things. Now we could get her some writing classes so she can learn to paint word pictures, but it is on West.
Hold on a moment. No. You're a very good attorney. You are not going to spin this. She told me the Walgreens, and it's not a Walgreens, it's a CVS.
I mean, she did say it was possibly a CVS, though.
One's red, one's green. Okay.
Well, she was-
said the gas station was attached to the Walgreens.
Well,
There's a road.
maybe it just got built.
No, there's a road.
Is it a newly paved road, Your Honor? It's a brand new road.
Here, no, I'm not recalling it. You can let your client know. I did look at the map.
Yes.
Story still doesn't make sense. Her motion for bond reduction still denied.
Thank you.
But thank you for the pictures.
Thank you.
I would have done the AI, Mr. Brown. Court calls the case People versus Montez Miller.
Assistant Public Defender Jay Bellinger on behalf of Mr. Miller on case ending in 1435, Your Honor.
And Edward Lucas on behalf of Montez Miller in 1434.
You both are requested. And your name, sir?
Montez Miller.
Thank you.
Your Honor, I did be put before the court an order for release to treatment. I'm hoping that the court will sign that so that he can find a bed as soon as one becomes available. Otherwise, we don't have any discovery on this case, so we'd be asking for an adjournment.
I'm just asking for an adjournment for video purpose.
Get these together. It's just the only thing holding him.
I think there's some nominal bonds in these two cases. I think there is a circuit court case that
He's got a violation up in circuit.
Got it.
Sir.
Probable cause conference, September 25th, 2025, 9 a.m. Bond will continue.
And Your Honor, as to the order for release to treatment.
Oh, I'll sign the one that Mr. Drukas. I'm not signing it. No, I signed it.
Thank you.
Appreciate it, Your Honor.
Thank you.
All right. Thank you, sir.
Okay.
I want everybody to drive around and I will call somebody's cases. I'll give somebody a reward where there's a pharmacy hooked to a gas station. If somebody shows me one of those, I'm just thinking. Those seem like two incompatible uses, but maybe I'm wrong. Court does call the case of People versus Tiffany Cash.
Assistant Public Defender Alexis serves with and on behalf of Ms. Cash and should be present via Zoom.
Bless you. Ms. Cash.
Perhaps she got up to use the restroom, Your Honor. Ms. Cash, can you please unmute and state your name for the record?
Think she can hear you in the restroom or what?
Your Honor, may we replay past this?
You enacting early. You're pushing it. Court does call the case People versus Justin Straight. And I've got a DOC.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Straight, who approached. Mr. Straight, can you please state your name for the record?
Justin Straight.
And Your Honor, I am asking for an adjournment. Although we are now in receipt of the media discovery, I have not had a time to go over that with my client. However, I do understand that the court did sign an order for release to treatment over the last few days.
Yes.
Please.
He did. Okay. So they have it already. So they're good. Okay.
So I can get in?
Yep.
Thank you.
Got
it.
Very good.
So this is the only thing holding, well, he's got a bond violation on this one, but this is the only thing holding him.
As far as I know, Your Honor.
Probable cause conference, September 25th, 2025.
You should be in it. You should be 9:25.
Bond
Should be in bed by then. Okay.
Thank you.
9:25 is your next day.
I'll be in bed.
You should be in it.
Court does call the case People versus John Coffey. Pardon? Mr. Coffee?
Yes, sir. Sorry about that, sir.
All right.
Did the prosecutor, okay, Ken Medach on behalf of Mr. Coffey. Mr. Coffey, can you please state your name for the record?
John Joseph Coffey Jr.
I have before me the two files that he is going to be pleading guilty to the charge of retail fraud in the third degree on each case.
That's correct, Your Honor.
That's correct, Your Honor.
That's the court's full understanding of the. Mr. Coffey, can you please raise your right hand?
Yes, sir.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record.
John Joseph Coffey Jr., sir.
All right, you can put your hand down. Sir, starting in case 251118, says court's understanding that you're going to need to be someplace stable, sir.
Yeah, I'm stop moving. Sorry about that, sir.
Maybe you could sit down, yeah, or stop walking.
All right.
Thank you.
Sorry.
Starting in case ending in 1118, it says court's understanding that you're going to be pleading guilty to the charge of retail fraud third degree. And likewise, in the other case ending in 1272, you're also pleading guilty to the charge of retail fraud in the third degree.
Yes,
Those
sir.
are misdemeanors punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, sir.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court.
Sir.
You understand that?
Yes, sir, I do.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
Again, starting in 1118, to the charge of retail fraud third degree, how do you plead?
Guilty, sir.
In case 1272, to the charge of retail fraud third degree, how do you plead?
Guilty, sir.
All right, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
I gave my lawyer permission to sign it.
And you went through that advice of rights form?
Sir.
Do you have any questions regarding any of the rights contained on that form?
No, sir.
All right. You understand that you'll be giving up your rights, specifically the trial rights defined or described in paragraph 5.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you are guilty of this offense in these cases?
Yes, sir.
Starting again in the case ending in 1118, on the date of April 2nd, 2024, at the location of 1103 South Main Street, City of Chelsea, Washtenaw County, State of Michigan, what'd you do at the Ace Hardware that makes you think that you're guilty?
I took some power tools that were for sale from the company and went past the point of sale.
Okay, so you went in, got power tools, tried to walk out of the store without paying for them?
Yes, sir.
At the time, was the store open to the public at the time?
Yes, sir.
Did you have anybody's permission to take that property?
No, sir.
And this was property that was offered for sale by Ace Hardware?
Yes, sir.
In the other matter, 1272, I can't complain on that. Give me one. All right. In that case, on the day February 25th, 2024, at the location of 5645 Jackson Road in Scioto Township, Washtenaw County, State of Michigan. What did you do at the Meyer that makes you think that you're guilty of that offense?
I went in the store to try to take merchandise that was for sale.
All right. Store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to take that property, did you?
No, sir.
And the property you took was property that was offered for sale by Meyer?
Yes, sir.
Sir, I do have to advise you that if I accept your pleas on these cases and you commit misconduct as defined under the Michigan court rule between the time of this plea and the time of your sentencing, you would not be the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir, I do.
You also understand you would not be entitled to withdraw your plea.
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to these pleas?
No, Your Honor.
I didn't hear a prosecutor. Ashley.
No, Your Honor.
All right, and has the court complied with the court rule and would it be proper to accept this defendant's pleas?
People are satisfied.
Defense is satisfied, Your Honor. Thank you.
Court will accept the defendant's pleas of guilty to count 2 in each of these cases. Count 1 in each case is dismissed. A pre-sentence investigation and report is ordered at 1483 probation. Sentencing in these matters will be set for November 3rd, 2025, 9 a.m. before Judge Fresno.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Bond will continue. Thank you, sir.
Thank you.
Case of the people versus Delco Thomas.
Alexander on behalf of people.
Lauren Brown, Deputy Chief Public Defender, appearing written on behalf of Mr. Thomas. Mr. Thomas, please state your name for the record.
Delco Thomas.
Thank you, sir.
Your Honor, today is the date and time set for probable cause conference. We are respectfully requesting this matter be set for preliminary examination.
All discoveries complete.
Best of our knowledge, Your Honor.
People have their witnesses available to 16.
We'll do our best, Your Honor.
Preliminary examination in person will be set September 16th, 2025, 9 a.m. That is before Judge Perry.
Let's do this.
Bond continued.
Thank you very much.
Thank you. Court calls case People versus Alicia Cargill.
Good morning, Robert J. Kilwell on behalf of Ms. Cargill. Ms. Cargill, would you state your name for the record?
Alicia Cargill.
Thank you.
Your Honor, here's where we stand on the situation. I met with Ms. Cargill at the prison on August 20th. We went over the police report. Co-defendant that previously pled to a misdemeanor. I believe I was offered that. Ms. Cargill wants to see the video of the incident. I have to make special arrangements with the prison in order to bring a computer into the Huron Valley prison. I need more time. I'm asking if I could have 3 weeks so I could make those arrangements.
Probable cause conference without objection will be set October 2nd. No, I don't have the October 2nd date. Right. I don't have October 2nd, so I meant September 30th, 2025 at 9.
Thank you, Judge.
Thank you. Bond continued. Court does call the case People versus Brandon Jackson.
Good morning,
to this honorable court. Carla Marable, P number 62755 on behalf of Mr. Jackson.
Your name?
Brandon Jackson.
Thank you. All right, what are we doing on this case?
Your Honor, I am now in receipt of discovery. There's a co-defendant in this case, and I'm representing him too. They have waived conflict. We're asking that it be set for a preliminary exam.
Who is the co-defendant?
He was up last week, Your Honor.
When did we set the? When did we set the?
Jackson. We haven't set
When
one
did we
yet.
set? When did we set that preliminary examination?
Your Honor, I'm not seeing that it was set for exam. The note that I have, I wasn't present for that, but I see that it was adjourned for a probable cause conference on the 11th.
I can confirm.
Okay, so you want this one set for exam and then next week you're gonna set the other one?
Correct, Your Honor, and I apologize for interrupting you. I'm so sorry.
No,
Yes.
it's okay.
Yes,
Okay.
because at the time, we didn't have discovery, but we have discovery now. It was sent out late yesterday.
Okay, did you wish these or is there gonna be a problem if they're heard on the same day?
I think that the prosecutor's gonna want them on the same day, Your Honor.
That's nice of you to concede to what they want. I've never seen that before.
But I mean, I prefer for them to be on the same day. I think it.
Yes, all right, very good. Yes,
I was going to say it would work if they're on the same day, but I'll defer to the court.
all right. And both individuals are in custody?
Yes.
All right. Well, I guess I could set them for the 16th. And then that other one, that would just be short notice, but you'd have to let me know to set it for the 16th so they don't remain in custody. Will that work for you, counsel?
No, I start a trial on the 15th.
All right. My next day, then it's the 23rd.
That
I have the
works, Your
20,
Honor.
the 23rd will work?
Yeah.
Okay. So I will set preliminary examination in person, September 23rd, 2025, 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Thank you. Bond will continue in this case. Thank you. Thank you, sir. Thank you. Court does call the case, People versus Jermaine Dalton.
And then on behalf of Peter, Your Honor.
Brian Bowling on behalf of Mr. Dalton, just state your name for the record.
Jermaine Dalton.
Thank you.
Your Honor, we're asking this matter be set for an exam. I believe all discovery to be complete.
And would the people have their witnesses available the 16th?
We'll do our best, Your Honor.
Paperwork, yeah. Preliminary examination in person, September 16th, 2025, 9 a.m. That is before Judge Washington. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case of the People versus David Davis.
Mayville for the people, Your Honor.
Public defender Hannah Apple appearing on behalf of Mr. Davis. Report you. Mr. Davis, will you state your name for the record?
David Davis.
Thank you. Your Honor, I am asking for an adjournment for plea negotiations, and I do have information regarding the bond violation that I want to address with the court.
Yes.
Okay. Your Honor, I did receive that yesterday. I contacted Mr. Davis. We went through that. I will note he's on a scram tether. My information that there's been no violation. I, of course, assume that the court's biggest concern is this positive test for cocaine. The first one, Mr. Davis is forthcoming. I mean, he does not disagree that both tests are positive for cocaine. He does not deny use prior to being arraigned. But of course, that second test on the 21st is of issue. Mr. Davis is taking this matter very seriously. He is employed. He did reach out to Dawn Farms yesterday to enroll in outpatient treatment. I did provide documentation to opposing counsel, confirming that he did a screening and confirming that he is scheduled for his assessment on Friday, September 12th at 11 a.m.
But he doesn't have a medical marijuana card either.
No, and he reports that he has stopped use. I don't know. I think that's roughly like 3 weeks. I don't know if that's, or maybe actually less than, yeah, about 3 weeks, if that is still in his system or not. But he reports that he has stopped THC use. But I think at this point, he at least, I would point out that he's had at least one test that he did not test positive for cocaine. He's on the Scram tether, confirming that he's had no alcohol use. And he's working on getting into treatment and doing the right thing and showing the court.
But he's not in treatment.
He has intake scheduled for the 12th. He did an assessment yesterday. He's beginning outpatient on the 12th next Friday.
I
September
will
12th.
adjourn his probable cause conference to the 11th, 2025, 9 a.m. But prior to his intake, defendant's remanded to the Washtenaw County Jail. Bond is revoked.
Understood. Your Honor, would you like a copy of the confirmation of his treatment for the file?
Why don't we bring that up on the 11th?
Okay,
Okay, because I just don't want to keep it in here. if
Sure.
I don't have.
I'll do that. Thank you, Judge.
Court calls the case, the People versus Enrique Davis.
Alexander, on behalf of the people.
Ready, Judge? Court shall feature Assistant Public Defender on behalf of Mr. Davis, who is approaching the podium. Mr. Davis, please state your name for the record.
Eric Davis.
Thank you. Thank you, Judge. I have had a chance to email the prosecutor and fit Mr. Davis. He is hopefully get this matter resolved, but he is not quite ready yet. We're still negotiating a resolution. May we have a 2-week adjournment?
Probable cause conference will be adjourned to September 25th, 2025, 9 a.m. Bond will continue.
9 a.m.
Yeah. Sign up. Court does call the case of People versus Rayshawn Dawson.
I read that on behalf of Mr. Dawson. Can you continue for the record?
Rayshawn Dawson. Thank you. How are you?
We're just gonna be asking for an adjournment, Your Honor. As long as.
Around your vacation.
No.
No, that's what I heard. Don't worry about it. We'll get you when we can, right? Okay.
It could be 2 weeks. It doesn't matter.
How long did you need for
2 weeks is okay, Your Honor. It need not be 3 weeks.
Well, I'll do this September 25th, 2025.
Yeah.
You wanted 2 weeks, but the other one you didn't.
I'm just
Because you're
following
gonna be
my
gone.
client's asking.
So what, you don't like this guy
I
as much as
like
the other
them.
one?
I do.
What? Is that what it is?
Again, I have
You were just
full
gonna
trust-
send him to somebody else? Is that what was gonna happen?
It was just the client's request.
And who's request? Oh, you're blaming him.
No, it's
He's not going on vacation.
not. You're right. It'll be my pleasure to handle him. That's what he said.
Nice save. September 25th, 2025, 9 a.m. Bond will continue. Thank you, sir. Court does call the case, People versus Sean Beater. Sorry, got it.
And my doctor on behalf of Mr. Veeder. Mr. Veeder, can you please state your name for the record?
Sean Visa.
You're gonna adjourn.
We are, Your Honor. There is a competency that has been ordered in 15th District Court. I have just learned about that. I am going to submit an order for this.
This
so
case.
we're able to.
Took a competency, we passed it already.
Sorry?
I took an evaluation already and passed it. I was deemed competent.
Okay.
The competency hearings on the 11th, I believe.
The 11th of
September.
September.
Mhm.
Okay, so why don't
Sorry,
I,
the 10th. The 10th.
why don't I do this then? I'll adjourn the probable cause conference to the 18th. And let's see what we come up with. September 18th, 2025.
Thank you, Your Honor.
Bond continue.
Mr. Veeder, someone will talk to you from the PD's office, okay?
Okay.
Court calls the case, People versus Sean Douglas. I don't know.
As a carrier, really on behalf of Mr. John Douglas, no relation.
Mr. Douglas, state your name for the
Seriously?
record.
You just can't let anybody have their own thing. You just had to jump,
Mr. Douglas, state your name for the
Good
record.
afternoon, Your Honor. Sean Douglas.
Thank you, sir.
Your Honor, we're asking for an adjournment in this matter. I was
Of course
just
you are.
drafting an email to Ms. Douglas. I want to see if Mr. Douglas would be eligible to get into the mental health treatment court. But I need to see if the people are on board with it as well.
Got it. Probable cause conference will be adjourned September 25th, 2025. Next bond continue.
Thank you, Judge.
Thank you. Court calls the case People versus Cartier Drains.
Oh, I'm sorry, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Cartier Drains. Come on up to the podium. You have a green sheet. I apologize. Sorry about this, Your Honor. I did write out, here it is. Your Honor, I am asking for an adjournment. Cartier and I have had discussions about this case, but I think we need to talk further about which direction this case is going to go in.
There's two things. One, I'll adjourn this probable cause conference to September 25th, 2025, 9 a.m. And as to his bond, I'll cancel his bench warrant and I'll reinstate his previous bond.
Thank you, Your Honor.
Thank you. Court calls case People versus Keon Ford.
People.
Mr. Ford, will you state your name for the record?
Yeah, Ford.
Thank you. I believe the court should be in receipt of an amended complaint.
And that is,
I am.
Okay.
and that's correct, Your Honor. This time the people would be moving to add that 3 of operating while intoxicated second and dismissing the count 1 of operating while intoxicated third. Once that's done, we'd just be asking us to be remanded back to the appropriate district court for further proceedings.
All right, so you're leaving count 2 in place? All right, so what I will do is count 1 is dismissed. I will indicate that the defendant is pleading not guilty to count 2, maintain his
correct
guilty plea to count 2. E-waive reading of that charge. Actually, it's just a change of the notice.
Correct.
All right. So I'll indicate that he's pleading not guilty to counts 2 and 3. I will set this for a pretrial for, is it October 2nd? I'll set it for a pretrial October 2nd, 2025, 9 a.m. before Judge Washington. Bond with all of its conditions will continue. Okay. Thank you, sir.
Thank you, Judge.
Court does call the case of the People versus Jonathan Griffith.
For Douglas for the people?
Assistant Public Defender Jay Bellinger on behalf of Mr. Griffith appears via Zoom.
Mr. Griffith, can you state your name?
Mr. Griffith, we can't hear you.
Jonathan Griffith.
Thank you.
And Your Honor, I am just asking to adjourn this matter for today as I work out
Your
negotiations.
hair looks okay. You're good.
I'm just asking to adjourn this matter today so we can continue negotiations.
Probable cause conference will be adjourned September 30th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond will continue.
Thank you, Your Honor.
Court does call the case People versus Taiwan Grace.
Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Griggs. I did file a Zoom request. Mr. Griggs, can you unmute yourself and say your name for the court?
Taiwan Griggs.
Thank you. You're requesting an adjournment.
I am, Your Honor.
Probable cause conference in this case will be adjourned to September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Mr. Griggs, please call my office, okay, sir?
Yes, ma'am.
Thank you.
Court does call the case People versus Suzette Hampton.
Assistant Public Defender, Chinazi Carey. Your Honor, on behalf of Ms. Suzette Hampton, who's referred to.
So you want to adjourn it to watch the video? Okay.
All right, Judge, we'll be asking for an adjournment. It looks like there is another piece of discovery that Ms. Hampton would like to review before we move forward.
September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Let's call the case People versus Janae Hardin Noel.
People?
I'm sorry?
This is a PD case, but there's no sign.
Oh, hello, what's your name?
Hello, Janae Hart-Noel.
The PD case.
Assistant Public Defender Jay Ballinger.
I see. What,
Oh.
what, hold on.
I'm a
Thank
PD.
you for stepping up, Mr. Ballinger.
Of course.
What were the rest of you doing?
I was already up.
He just cut you off. Is that what it was? Okay, all
I'm
right.
gonna get an adjournment today, okay?
Now's always got it. All right, what are we doing on this case?
Your Honor, I would ask for an adjournment on this case so that we can go over discovery with Miss Hardin Noel.
Okay. Probable cause conference in this case. During September 25th, 2025, 9 a.m.
Okay.
Bond will continue.
Okay.
Thank you, ma'am.
Thank you.
Thank you, Your Honor.
Court does call the case People versus Ardashir Hassani. Hold on a minute. You just came up and got in his way? I can really? What?
When she walked.
What? I called somebody. What? Somebody's gonna come to the podium. Just have a seat.
Ready to torch your fees, assistant public defender on behalf of my client. Please state your name for the record.
My name is Ardashir Hassani.
Thank you, sir.
Thank you, Judge. I have emailed with the prosecutor and spoken to my client. He is requesting an adjournment. He is hopeful that I am able to persuade the prosecutor to allow him into a treatment court.
Probable cause conference, September 30th, 2025, 9 a.m.
Thank you very much, Judge.
Bond
Oh,
continues.
he wanted me to ask one more thing, Judge. He is an Eastern Michigan student. And he,
Oh, yay.
I'm excited about it. He's in class.
What's he studying?
Computer science.
Eh, go ahead.
He's in class from 9 to approximately 2 o'clock. He was hoping you might consider adding him.
What?
He's in class from 9 to 2 o'clock.
He doesn't
was
go to class.
hoping you might add him to a 3 p.m. block if you have one that day.
Wow, no.
Fair enough.
All right.
I told him I'd ask.
What I can do, well, I don't know if we can do this. That day ends at noon.
Oh, okay.
Ends at noon.
Yes.
Okay.
So you have to be here in the morning.
In the morning.
Yeah.
Gotcha.
That work?
What's the first class you have?
I have a networking class and I have an exam that day, Judge.
You have an exam that day?
Yes.
Wow, you're gonna fail.
Truly sorry.
Here's what I'll do. And I'm gonna only do this because Ms. Akin really got your way coming to the podium. I'll adjourn this to October 8th,
October 8th.
2025.
Thank you, Your Honor.
9 a.m. Pardon? The 9th. Yes, it would be. Thanks for correcting me out in public. October 9th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, sir.
Thank you.
Thank you, Judge.
Court calls the case People versus Nisa Hill. Announcing that right.
Or yeah, the Assistant Public Defender with, and on behalf of Ms. Hill, who's approaching. Ms. Hill, can you say your name for the court?
Nasai Hill.
Antonio.
And Your Honor, I'm requesting an adjournment. This is the first PCC, and we have to talk about the case further.
Probable cause conference September 25th, 2020.
Thank you, Your Honor.
Bond continued. Thank you. Court calls the case People versus Randy Hockenberry.
Assistant Public Defender Chelsea Virgil, and on behalf of Randy Hockenberry, please state your name.
Randy Hockenberry, sir. Thank you.
Your Honor, we're just asking for a brief adjournment in this case to finish up a plea discussion.
Probable cause conference September 18th, 2025, 9 a.m. 5 continued.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Dalton Howard.
Or yeah, the Assistant Public Defender with, and on behalf of Mr. Dotton Howard, who's approaching. Could you state your name for the court?
Don Howard.
Thank you.
And Your Honor, we did just receive media discovery. It must have been sometime before. It was uploaded this morning at like 9:15. So I just need more time to review that.
September 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Calvin Johnson.
Cash calls for the people. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Johnson. Now, Mr. Johnson, will you state your name for the record?
Calvin Johnson.
Thank you. And Your Honor, he has executed a preliminary exam waiver.
Okay. Sir,
Yes,
you're
sir.
waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on all 3 counts.
Your Honor, we acknowledge receipt of the information. My client would waive formal reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all charges. Pretrial will be set for
October 27th at 1:30 with Judge Hamoud.
October 27th, 2025, 1:30, Judge Hamoud. Bond will continue.
Thank you.
Thank you. Court does call the case of the People versus Serrano Johnson. Serrano Johnson.
That goes for the people.
Chelsea.
Sorry, Your Honor, Assistant Public Defender Chelsea Virgil with on behalf of Cyrano Johnson. Did you state your name already?
No, Serrano Johnson.
Thank you.
Your Honor, we are asking for an adjournment. There has been an offer in this case that would include my client's participation in sobriety court, so we're asking to adjourn for that purpose.
How much time do you think you're going to need to try to get an answer from them? Have we started that process yet?
I did provide the court with a form. If
I do have
Okay.
it, but
I think it's 3 to 4 weeks. I don't know. If it's-
gotcha. Okay. Then let me do this. Let me probable cause conference to September 30th, 2025, 9 a.m. That's a Tuesday. Okay. Bond will continue. Thank you. Vic, how you doing?
I'm doing better, a lot better.
Are you?
I am.
All right. You had a whole lot of folks worried about you. Huh?
Indeed.
All right. Take care.
All right.
Court calls case People versus Stephen Johnston.
Trevor Mayville for the people.
Brian Bowling on behalf of Mr. Johnston, who should be on Zoom, hopefully.
You know, when you said it. at
Stephen
first,
Michael Johnston, Your Honor.
Thank you, sir.
I never know. I never know.
Right.
Your Honor, I'm asking for another adjournment. It's my understanding that this was adjourned previously for him to get into Bear River.
Yeah.
He indicates to me that a bed has become available to him, to his knowledge. He should be able to check himself in there tomorrow, at latest Saturday. So I'm just asking for the court's consideration.
Then he's gonna be out of communicado for a little bit, and we gotta try to figure that out.
That's
So,
correct.
let me do it this way. Probable cause conference, September 30th, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you.
Thank you, sir. Court calls the case People versus Desmond Jones.
Brian Bowling on behalf of Mr. Jones. State your name for the record.
Desmond Jones.
I'm sorry. Judge, Mr. Cook and I have started some negotiations with respect to this matter, and I think we're close to finalizing something. I'm just asking for an adjournment so we can.
Who's the hangup, Cook? No, never mind.
Usually, usually is
don't
me
even
this time,
answer
Your Honor. So we just need to dot the i's across.
Yep, I took a shot at you. All right. Probable cause conference, September 25th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thanks, sir. Mr. Cook didn't know how to answer that.
I work with him every day. I thought we had a better relationship.
Oh, he didn't get offended by me? Oh, I'll have to get better. That means I get another shot. Nope. Court calls the case People versus Gerald Manning.
And then on behalf of the people,
Brown deputy. With, on behalf of Mr. Manning. Mr. Manning, please state your name.
Gerald Manning.
Thank you, sir.
Yes, sir.
Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting that this matter be set for preliminary examination.
Discovery is complete.
Your Honor, actually, let me rephrase that. Actually, we'll need a couple of weeks because there's information that we think we should have. The prosecution doesn't have it. There's another source from which we will have to get this information. So we'll need 2 weeks.
You'll need to adjourn it out.
Yes.
Probable cause conference, September 18th, 2025. Will that be enough time to get accomplished?
Absolutely.
What you need? Okay.
Absolutely.
9 a.m. Bond will
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, sir.
Thank you.
Court does call the case of the People versus Matthew Nicolai.
Trevor Mayville for the people.
For the judge, Marshall Eastern Assistant Public Defender on behalf of Nicolai. Mr. Nicolai, please state your name for the record.
Matthew Arthur Nicolai.
Thank you.
Thank you, Judge. I am requesting an adjournment on the file. I have reached out to the people to start negotiations trying to resolve this matter. We have not yet resolved this, so I will be requesting an adjournment.
Probable cause conference, September 30th, 2025, 9 a.m. That's Tuesday. Bond will continue.
Thank you very much, Judge. September 30th. Judge.
Court calls the case People versus Tiffany Cash.
Assistant Public Defender Alexis Sept on behalf of Ms. Cash.
Hello,
Hello. What's your name?
Tiffany Cash.
Okay, you're back with us. Okay, good enough.
Thank you for passing the matter, Your Honor. It does sound like she was having a little bit of technical difficulty.
No, I passed it for Miss Cash. It had nothing to do with you.
Well, Ms. Cash thanks you for that.
All right.
Your
Okay.
Honor, we'd respect the request that this be set for preliminary exam.
Set for a preliminary?
Yes.
All right, discovery is complete.
To my knowledge, Your Honor.
People have their witnesses available the 16th. Court does call the case People versus Sean Walker.
Good afternoon, Your Honor. Craig Paffin appearing on behalf of the people.
All right, thank you.
Assistant Public Defender Alexis Zerbs on behalf of Mr. Walker, who may be on Zoom.
Have him? I don't have him.
Your Honor, I did my attempts to try to reach out to him, had no success. For the record, we'd be requesting an adjournment.
What is the current amount of child support owed?
Your Honor, in this particular case, it is an arrearage only file. At this time, it is $441.72. This file previously had 2 felony informations filed in years past. And then when he caught up, they were both now lead. This is the 3rd time we're here on this file.
You said the amount of the arrearage is
41 and 72 cents.
Bench warrant will issue. Bond set in the amount of $441 cash.
Thank you, Your Honor.
That warrant will issue immediately. Thank you.
Your Honor.
Court does call the case of the People versus Jimmy Murray.
Ready, Your Honor. Good afternoon, Raymond Cook, People.
I'm Roderick Green for the defense, Your Honor. Good afternoon.
Oh, my goodness.
Good to see you, Judge.
Oh, my goodness. I see him out in the community, see him other places. Always say hi to me and everything. Always come down here visiting me. Doesn't appear face.
Good to see you.
Doesn't say I'm gonna show up, and all of a sudden just shows up.
How are you doing today?
Yeah, I'm doing great.
Is it good? Good to see you.
It is a blessing seeing you, sir.
Thank you, Your Honor.
All right.
Your Honor, we're substituting in for the public defender, and we're asking for a 2-week adjournment so I can get discovery and get up to speed on this case.
All right. Without objection, will the 25th work for you?
I'm sorry?
Will the 25th work for you, sir?
Is the 18th available, Your Honor?
Yeah, with you and about 200 other people, yeah, it's available. We can squeeze you in.
Can you? On the 18th?
18th?
Yeah, that's fine. I don't mind.
Cause Conference, September 18th, 2025, 9 a.m. or as your invitation indicates. Bond will continue.
Yes, sir. Thank you very much, Your Honor.
Thank you.
Good to see you.
Good seeing you. Court does call the case of the People versus Antonio Young, all 3 of his cases.
And then on behalf of People.
Right, Judge, worship, please, Judge. On behalf of Mr. Young, who is approaching the podium.
And good afternoon. Sorry, Tarsha.
No problem.
always cutting people off. Sorry.
Go right
ahead.
Okay,
it's okay. I'd rather hear from you.
So
go ahead.
So would I, Judge.
Thanks, Judge. Good afternoon, Judge. Christina Costantino appearing with and on behalf of Mr. Young, and I'm appearing in case number ending in 1177 FY.
And I believe we have the remainder, Judge.
All right.
Young, please state your name for the record.
Antonio Young.
Thank you, Judge. I have spoken to Ms. Costantino and emailed with the prosecutor's office. My understanding is we're hoping for an adjournment to seek a global resolution on all files.
All right.
That's correct.
Will the 30th work for you? It's a Tuesday.
It will on our end.
It works on my end as well. Thank you, Judge.
All righty. September 30th, 2025, 9 a.m. On all these matters, bond will continue.
Thank you, Judge.
Thank you.
Thank you.
Oh, yeah, okay.
Court does call the case of the People versus Mary Collins.
Miss Riddell's case. Yeah.
A lawyer?
Are you, well, don't you leave.
Howard, on behalf of Mary Collins, is approaching the podium and will be standing to my right. Ms. Collins, please state your name for the record.
My name's Mary Collins.
All right.
Thank you, Judge. Today is a date and time set for probable cause conference. I did speak to the people this morning, and they have extended an offer which we intend to take. For the record, that offer is to dismiss count 1 and to plead guilty to an added count 2 and 3 of attempted resisting obstructing.
That's what the plea form indicates, that she'll be pleading guilty to 2 charges of attempted resisting and obstructing the 1-year offenses. Upon her successful plea to those charges, count 1 would be dismissed. May I have her sworn?
Right. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
State your name.
Mary Collins.
Ma'am, it is this court's understanding that you're going to be pleading guilty to 2 charges of attempted resisting and obstructing.
That's what I understand.
Okay, those are misdemeanors, punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Okay.
Yes, yes, yes.
Yes.
Yes. It's gotta be yes.
You do understand that, ma'am?
Can you say?
So is it a hearing problem?
Are you having problems hearing?
I can't hear very well.
Okay, it's okay. We have some equipment that will, that will probably help you. Okay?
Okay. Something about 1 year, but I couldn't hear the rest.
You know, that's fine. Yeah, we'll get you the hearing. We'll get you some mics and we'll get you mic'd up.
Okay, Ms. Collins, is that better for you?
Yes, it is. Thank you.
It is.
Thank you,
Good stuff. All right. The court's understanding is that you're pleading guilty to 2 charges of attempted resisting and obstructing.
Yes.
That's your understanding? Okay. Those are misdemeanors punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Yes, I do.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court.
Yes, I understand that.
All right. So understanding all of that, you still wish to plead guilty
Yes.
to the charge of attempted resisting and obstructing as contained in count 2. How do you plead?
How do you plead to the resisting obstructing? Attempted.
Attempted, yes, I plead guilty.
All right. To that same charge as contained in count 3, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
All right. I need you to look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights that are contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will,
Yes.
and because you believe that you're guilty of these offenses?
Yes.
On the date of June 17th, 2023, at the location of North Maple and Miller Road in the city of Ann Arbor, Washtenaw County, state of Michigan, did you come into contact with 2 officers from the Ann Arbor Police Department?
Yes.
Okay, what happened?
I was trying to get out of Ann Arbor. I didn't realize that they were following me until I got onto 23. When I got on 23, I looked in the mirror and there were 4 officers' cars chasing me down 23. So I pulled off the first exit.
So if I may, Judge.
Please.
So did you have opportunities to pull over before you did? Did you drive on longer than you needed to?
I drove as far as to the exit on Territorial Road.
Okay. Could you have pulled over earlier?
Could I have pulled over on the side of the
Yes.
highway? I probably could have.
Okay.
Between Miller Road and North Territorial?
After Miller Road, I got onto 14 and then 23. And then I got up when I saw they were chasing me. I pulled off on Territorial Road exit.
If that's a ways, but okay.
Yeah, it's a ways.
And you could have pulled over. Okay,
I
did you
could-
know they were trying to pull you over?
Once I saw 4 police cars side by side on 23, yeah. I realized they wanted me to pull over.
So at what point did you notice that there were 4 police cars behind you?
I was onto 23 North. You understand?
Yeah.
Your Honor, with defense counsel and court permission, may I board here?
No objection.
Go for it.
Thank you, counsel.
Ms. Collins?
Yes,
On that date, didn't your vehicle come to a stop at the intersection of Miller and Maple?
it did.
And wasn't there an officer at your window telling you to roll down your window?
There was an officer by my window and there was one in front of the car.
And then you drove away
Yes,
and then drove onto 23?
yes,
And eventually they had to use stop sticks to stop your car?
yeah.
Okay, I'm sorry.
Okay, so,
Thank you, counsel.
I mean, yes,
so ma'am, at Maple and Miller, you drove around a police officer that was in front of your vehicle?
yeah, I told the guy at my window to have the officer get out from in front of my car because I didn't want to hurt anybody. And then I drove on.
At the time, you knew that they wanted you then to stop because they had some business with you.
Yes, I knew they wanted me to stop for some reason.
Okay.
Defense is satisfied at this point, Judge.
Okay, ma'am, I do have to advise you that if you do commit misconduct between the time that I accept your plea and the time of your sentencing, you would not be entitled to, the court would no longer be bound by any sentence evaluation or recommendation regarding your sentence. You understand that?
Yes,
And the other thing is that you would not be permitted to withdraw your plea. You understand that?
yes,
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Have I complied with the court ruling? Would it be proper to accept this defendant's plea?
People are satisfied.
You have and it would.
Okay. Court will accept the defendant's pleas of guilty to counts 2 and 3. Count 1 is dismissed. The pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
September 22nd at 8:30.
September 22nd, 2025, 8:30 before Judge Perry.
Thank you, Judge.
Thank you. Bond will continue. Thank you, ma'am.
thank you, Your Honor.
We'll talk out loud. Mike. And I have some equipment for you, Alan.
You want these back? Thank you very much.
Wow. You're welcome. Court does call the case of the people versus Christopher Taylor.
Good afternoon, Your Honor, Raven Cook for the people.
Oh, no, I'll wait.
Proud on behalf of Mr. Taylor, who's approaching the podium. Mr. Taylor, please state your name for the record.
Christopher Taylor.
Thank you.
Your Honor, today's a date and time set for preliminary exam. We are asking that the matter, today's date and time set for probable cause conference. We're asking that it be set for preliminary exam.
Discovery is complete.
Yes, Judge.
People have their witnesses available to 16.
Yes, Your Honor.
Preliminary examination will be set in person September 16th, 2025, 9 a.m. before Judge Washington.
I'll get this.
Bond will continue.
Thank you, Judge.
Thank you. Court does call the case of the people versus Lamine Kaba.
For Douglas for the people.
Public Defender Chelsea Regios with and on behalf of Cabo. Mr. Cabo, please state your name. Your Honor, we're asking to adjourn for a competency referral. I provided the order to the court this morning.
All right. Give me 90. A forensic evaluation will be ordered. Set a competency hearing for December 4th, 2025, 9 a.m. Bond continued. Thank you. Court calls case People versus Amanda Lewis.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Lewis, who should be appearing via Zoom.
Oh, there she is.
Lewis, will you state your name for the record? See her there.
Yeah, she's there. Miss Lewis, are you trying to talk to us?
Yes, Amanda Lewis.
Okay, there you go. Okay, I wasn't hearing anything.
Thank you.
All right.
Your Honor, I'm asking for an adjournment for some continued plea negotiation. May I approach?
Yes. Thank you. Probable cause conference will be then adjourned to September 25th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you, Ms. Lewis. You're welcome. Court calls case of the People versus Letta Jones.
Good afternoon, Your Honor, Raymond Cook for the People.
Oh, there she is. Three jails. Ma'am, while we wait for your attorney, can you state your name, please?
Lita Jones.
Lita, okay.
Assistant Public Defender Chelsea Vergils, on behalf of Lita Jones. Ms. Jones, please state your name.
Lita Jones.
She already did.
Oh, I'm sorry, Your Honor. I am asking for an adjournment to receive media discovery in this case.
Probable cause conference, September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you, Ms. Jones.
Thank you.
Court calls case People versus Nathaniel Jones II.
Assistant Public Defender Chinaki Carrier and really on behalf of Mr. Nathaniel Jones, who's approaching Mr. Jones, when you get to the podium, state your name for the record.
Nathaniel Jones.
Thank you.
Your Honor, we're asking for an adjournment. I think we're close to a resolution. The need to confirm some things.
Cause conference, September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Ronald Jones.
Remember that is on behalf of Mr. Jones, who's here in the courtroom. Can you say your name for the record?
Ronald Jones. Thank you.
Your Honor, we're asking for an adjournment so that we can discuss plea negotiations with the prosecutor.
The 18th won't work, right?
You can do the 25th for this one, if Your Honor is so inclined.
Doesn't want to say why now this time. Probable cause conference, September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Have a blessed rest of your day, Honor. Court does call the case of the People versus Zion Jones.
Good afternoon, Your Honor, Raymond Cook for the People.
Assistant Public Defender Jay Bellinger on behalf of Mr. Zion Jones, who appears via Zoom. Mr. Jones.
Oh.
Hello.
Hello.
Can you hear
State your
me?
name.
Zion
Yeah,
Jones.
we can hear you. I need a camera.
Set my camera on.
Oh, no, you don't.
It was on a second.
I need to go back to a current. Okay.
It's not on?
No, sir.
Your Honor, for the record, I do recognize my client's voice.
Okay. Yeah, I get it, but okay. What are we doing? So
Your Honor, I understand,
it's gonna be all day with new technology of Zoom.
I understand we're here for. There he is.
Oh, yep, there he is. Okay, now.
Your Honor, I understand we are here for an arraignment and added charge. As to that, we will waive a formal reading, stand mute at this time.
Yes, actually, you added, and added count 4. Yes, so you were arraigned, defendant being arraigned on count 4, standing mute, court will enter not guilty plea. What are we doing otherwise?
As to the PCC today, Your Honor, we are asking that this matter be set for preliminary examination. To the best of my knowledge, discovery is complete.
Got it. People have their witnesses available on the 16th.
Yes, Your Honor.
Preliminary examination will be set September 16th, 2025, 9 a.m. before Judge Perry.
Thank you, Your Honor.
Bond will continue. And Mr. Jones?
Yes, sir.
You failed to appear yesterday for a hearing before me on a Pittsfield Township matter. It might have been a state case, but you didn't appear. We adjourned that out. Do we have what date? So I adjourned it out because you normally do appear and didn't issue a bench warrant, but you're set for September 17th to be here on your misdemeanor case.
Okay.
Okay.
Yes, sir.
All right. You're welcome.
Thank you.
Appreciate it.
Court calls the case People versus Shannon Kiesling.
Brian Bowling on behalf of Ms. Keesling, Your Honor. Excuse me, just state your name for the record, please.
Shannon Kiesling.
Thank you.
Your Honor, I'm asking for an adjournment. We just had video uploaded into our system yesterday, so I haven't reviewed it and haven't had a chance to review it with my client.
All right. Probable cause conference will be adjourned September 30th, 2025, 9 a.m. That's a Tuesday. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you.
We'll be in touch. Thanks.
Court calls case People versus Christopher Nieper.
Assistant Public Defender Jay Bellinger on behalf of Mr. Nieper, who appears via Zoom.
Is this new? Okay, I didn't think so. I don't have a date when it came in.
Yeah, 7/23.
Okay.
Mr. Nieper, can you please state your name for the record?
Christopher Nieper, Your Honor.
Thank you, Your Honor. And we are just asking for an adjournment for progress in terms of asking for a resolution. My understanding is that my client is at Bear River and then doing outpatient treatment. So we're just tracking that for purposes of an offer.
So is he currently at Bear River?
Your Honor, my understanding, Mr. Nieper, you're currently at Bear River, correct?
Yes, Your Honor.
All right. What I'll do then is probable cause conference will be adjourned out to October 9th, 2025, 9 a.m. Or as your invite indicates, bond continue.
Thank you, Your Honor.
Thank you.
Thank you, sir. Court calls the case People versus Sandra Law.
People.
Judge. Court shall feature Assistant Public Defender on behalf of Ms. Law, who is approaching the podium.
Sandra Law.
Thank you.
Thank you, Judge. I turn to the court a copy of our adjournment request for 2 weeks. We're still trying to reach a resolution on this matter. My understanding is that there is also a community corrections report in the file about her missing her testing with community corrections. She indicates that she is testing through her psychologist.
It's my outpatient therapy at Hagera. They test me at Hagera, and I talked to her and she said she sent them to Miss Kerr yesterday and also to Mr.
Haven because I'm on probation to 14B. So I've been dropping there for 14B.
Oh,
And when I seen you, I asked you
So-
if I could drop there and you said yes, but they evidently said they sent them yesterday.
okay, so, and you signed a release so that you.
Yes, I did. Yeah, they sent an
Okay.
email to both of them.
So you're testing there, okay.
Yes. Only because I don't have to pay for it.
Okay,
I'm in a bad situation with surgery I have to have and everything, so.
then what I will do is I will adjourn this probable cause conference at defendant's request, September 30th, 2025, 9 AM. That's a Tuesday. Bond will continue.
Thank you, Judge.
Thank you.
Your Honor. Thank you.
Court does call the case, People versus Levy or Lawson Morton.
Ready again, Judge. Torshell Feaster, Assistant Public Defender on behalf of Mr. Lawson Morton. Please take the record, sir.
Xavier Lawson Moore.
Thank you, Judge. I have recently been in touch with the prosecutor on this matter. We are discussing two potential offers at this time, and going to discuss that further with my client. If we could have a briefing, matter resolved.
Probable cause conference, September 30th, 2025, 9 AM. Again, that's a Tuesday. Bond.
Thank you, Judge.
Thank you.
Your Honor.
Court calls case, People versus Austin Lovestone.
Assistant Public Defender Chelsea Regios with and on behalf of Austin Lobestall. Mr. Lobestall, please state your name.
Austin Lobestall.
Your Honor, we are asking to,
He's trying to pay restitution.
yes.
So how much more time does, I mean, where is he in that process?
I believe he's going to make his first payment today, which is going to be a substantial part of it.
Then how much more time is he gonna need to complete what he needs to do?
Probably a month.
A month? Would that be about right, sir?
Yes.
All right. Probable cause conference will be adjourned October 9th, 2025, 9 AM. Bond continues.
Thank you.
Thank you.
Thank you, sir. Court does call the case, People versus Jeremy McGee.
Assistant Public Defender Alexis Sept with and on behalf of Mr. McGee. Mr. McGee, can you unmute and state your name for the record, please?
Jeremy Michael McGee.
Your Honor, we'd respectfully request that this be set for preliminary exam.
Discovery is complete.
My knowledge.
People have their witnesses available the 16th.
We'll do our best, Your Honor.
Preliminary examination in person, September 16th, 2025, 9 AM. That is before Judge Washington. Bond continued.
Thank you, Your Honor.
Thank you, Judge.
Thank you. Court calls the case of the People versus Carol Mager.
Assistant Public Defender Chelsea Regios with and on behalf of Carol Mager, who approaches. Can you please state your name?
Carol, you want my middle name? Carol Ann Mager.
Thank you.
Your Honor, we are asking to adjourn this for a competency referral as submitted in order to the court this morning.
I'm sorry. Okay. The order's been signed? But is it? Just want to make everything's out of whack here. Okay, got it. Forensic evaluation having been ordered. Set a competency hearing for December 4th, 2025, 9 AM. Bond continued. All right, thank you. Thank you, Ms. Mager.
Thank you.
Court does call the case of the People versus Tina Magira.
Assistant Public Defender Alexis Zerbs with and on behalf Ms. McGear, who's approaching the podium. Please state your name for the record.
Tina McGear.
Your Honor, we'd be requesting an adjournment for some continued discussions with the prosecutor.
Probable cause will be adjourned September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Curtis Martin.
Assistant Public Defender Alexis Zerbs with and on behalf Mr. Martin, who should be present via Zoom, Your Honor. I believe that may.
Curtis Martin.
Hello, yes, I'm Curtis Martin.
Okay, you got it. Cause couldn't have been Samuel Freeman because he's having a sandwich.
Thank you, Your Honor. At this time, we'd be requesting an adjournment. There has been a offer worked out between me and Mr. Mayville. At this time, we just kind of need to execute the documents, have further discussions with Mr. Martin, and we should be able to proceed at the next probable cause conference.
Probable cause conference will be adjourned September 30th, 2025, 9 a.m. That's a Tuesday. Bond will continue.
Thank you, Your Honor.
Court does call the case People versus Derek Martin.
Brian Bowling on behalf of Mr. Martin. The record.
Derek Martin.
Your Honor, subsequent to submitting the green sheet in this matter, I've learned that there is no additional video we are waiting for. But even with that being said, I just wanted to state that for the record. We're still going to ask for an adjournment of the probable cause conference because I just learned that, like I said, subsequent to submitting that form. So I want to discuss that implication with Mr. Martin.
Probable cause conference, September 25th, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you. Court calls case People versus Jeremy Mazza.
We're ready now. Lauren Brown, Deputy Chief Public Defender, with and on behalf of Mr. Mazza, who appears by Zoom. Mr. Mazza, please state your name for the record.
Hello, Your Honor. My name is Jeremy Meza.
Meza.
Your Honor, today is the date and time set for probable cause conference. We are basically trying to get an update on Mr. Meza's progress in the Bear River program. So we don't have any reports from the facility itself.
All right, Mr. Meza, what are you? How much longer are you scheduled to be at Bear River?
I'm being released from Bear River this Saturday on the 6th, and I'm going to be residing in Oasis. It's a sober living program in Emmett County.
Right. Okay. So let's do this. So you can do that, get settled there. How are you feeling?
I'm feeling great. Besides, it has nothing to do with this case, but my wife divorced me while I was up here. That's
okay. Sorry to hear that.
It's
but you can make it through it, right?
Yes.
All right. Probable cause conference all set for September 30th, 2025.
Thank you, Your Honor.
9 a.m. That's a Tuesday. Okay. All right. Thank you, sir.
Thank you.
Keep up the good work, all right?
Thank you, Your Honor.
Court does call the case of the People versus Patrick McGee.
Good afternoon, Your Honor. Raymond Cook with the People.
Assistant Public Defender Alexis Zerbs on behalf of Mr. McGee. Your Honor, I did reach out. He's appeared at the last couple court dates, so I'm surprised to not see him present today. I have no explanation for his failure to appear, but we were going to be requesting an adjournment for the record.
E, no response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court does call the case of the People versus Sean Mello.
Sympathizer on behalf of Mr. Milo, can you please say your name for the record?
Sean Milo.
We're asking for an adjournment, Your Honor, please, to continue the negotiations with prosecution. Oh,
No, you're not. Get it to me. September 25th, 2025, 9 a.m. Bond continued.
thank you, Your Honor.
Thank you.
Thank you, Your Honor.
I'll await the green sheet.
Thank you, Your Honor.
Court does call the case of the people versus Jordan Miller.
Brian Bowling on behalf of Mr. Miller, Your Honor. State your name for the record.
Jordan Miller.
I think it's a religious.
It's a religious.
Yeah, it's a religious.
Thanks. Thank you. Thanks, Judge. Your Honor, we're asking that this matter be sent for a preliminary examination. To my knowledge, all discovery is complete.
Preliminary examination in person at September 16th. People would have their witnesses, correct? 2025, 9 a.m. That is before Judge Perry. Okay. Bond will, thank you, sir.
Thank you, Your Honor.
Thank you.
That's called the case, people versus Javon
Thank you,
Mills.
Your Honor.
Thank you.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Mills, who is appearing through Zoom. Mr. Mills, will you state your name for the record?
Yes, Javon Mills.
Thank you.
Your Honor, we are asking for an adjournment for some plea negotiations. I spoke with Mr. Mills. I'd like to provide Mr. Kennedy with some information regarding his case.
Probable cause conference, September 30th, 2025, 9 a.m. That's a
Thank you.
Tuesday, bond continue.
All right, thank you.
Thank you.
Thank you, sir. Court calls the case, people versus Omar Mohammed.
Assistant Public Defender Alexis Sept with and on behalf of Mr. Mohammed, who's approaching. Please state your name for the record.
Omar Mohammed.
Your Honor, we are asking for an adjournment for some
Of
further
course you are.
discussions with the people and to provide some mitigation information as well.
It's like her 40th adjournment today.
It's been painful for myself too, Your Honor.
Why are you smiling?
It's the uncomfortable smile.
Is that what that is?
It is, yes, Your Honor.
Probable cause conference will be adjourned September, make it September 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case people versus Bryant Murphy.
Assistant Public Defender Chelsea Virgios with and on behalf of Bryant Murphy. Mr. Murphy, please state your name.
Brian Murphy.
Thank you.
Your Honor, I don't have a signed form, but Mr. Murphy would like to waive his right to a preliminary examination to seek HIDA in circuit court.
All right. Is that correct, Mr. Murphy?
Yes, it is.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause, by the standard of probable cause, that this offense was committed and that you committed it. You understand that?
Yes.
You understand that by waiving, you will not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
We acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
October 23rd at 1:30 with Judge Slay.
October 23rd, 2025, 1:30 before Judge Slay.
Okay. Thank you. Have a good one.
Bond will continue. I'm sorry, what'd you say, sir?
I said, have a good one. Thank you.
Will it be Zoom?
Yeah.
Oh, you told me to have a good one. I'm sorry. It's muffled on my end here. You do the same. All right. Take care. Court calls the case of the people versus Marcus Napier.
Good afternoon, Your Honor. Raymond Cook for the people.
And good afternoon, Laura Yagi, Assistant Public Defender, on behalf of Mr. Napier. Mr. Napier, if you are on Zoom, please unmute and state your name for the court.
Nope.
Your Honor, I saw that on Axfield, he had an MDOC hold and he's not still in our jail. So I am wondering if there is a good chance that he's incarcerated in the MDOC facility. I don't know if that would make a difference in terms of the court not issuing a bench warrant.
Nope. But thanks for the info.
Understood, Your Honor.
Bench warrant will issue, bond 10,000, cash surety. Warrant will issue immediately. Thank you.
Thank you.
Court does call the case People versus Michael Owens.
Good afternoon, Your Honor. Raymond.
Apple.
So sorry.
Assistant Public Defender Hannah Apple
No,
appearing on
it's Kennedy's fault. Oh, I know.
on behalf of Michael Owens.
Oh, there he is.
Oh, there he is.
Mr. Owens, will you state your name for the record?
Michael Owens.
Hands out of your pocket. Hands out of your pocket, yeah.
Okay.
Your Honor, we're asking that this matter be set for a preliminary examination.
All right. All discoveries complete.
To our knowledge, yes, Judge.
All right. People have their witnesses available the 16th.
Yes, Your Honor.
Preliminary examination in person will be set September 16th, 2025, 9 a.m. That will be before Judge Washington.
Back here in this courtroom, but in front of Judge Washington, okay?
Bond will continue.
But in front of Judge Washington, okay? Thank you, Judge.
All right. Thank you, Mr. Owens. Court calls the case of the People versus Ryan Phelps.
And Laura Yagi, Assistant Public Defender, on behalf of Mr. Phelps. Your Honor, I've attempted communication with Mr. Phelps. I have no representation.
Yeah. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000 cash surety. That warrant will issue immediately. Court calls case of People versus Cherie Powell.
Good afternoon, Your Honor. People.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Powell, is it Virginia? Can you state your name for the record?
Cherie Powell.
Your Honor, we're asking that this matter be set for a preliminary examination.
All right, discovery is complete.
To our knowledge, yes.
People have their witnesses available on the 16th.
Believe the victim should be double check that liquor really quick. We're good. Thank you.
Preliminary examination in person will be set September 16th, 2025, 9 a.m. That will be before Judge Perry. Bond will continue. Thank you, ma'am.
Thank you.
Court does call the case of the People versus Samuel Freeman.
Assistant Public Defender Chelsea Vergils with and on behalf of Samuel Freeman. Mr. Freeman, please state your name.
Samuel Freeman.
What kind of sandwich was that?
Basic peanut butter and jelly. My wife just.
Oh, was it?
Yeah.
No, it looked like you were enjoying it. That's all right. I just wonder what was in it.
Magic on it.
What'd you say?
My wife put her magic on it.
All right. All right, what are we doing?
Your Honor, we're asking to adjourn briefly to finish up our plea discussion.
Okay. Probable cause conference. September 25th, 2025, 9 a.m. Or as your invite indicates, bond will continue.
Thank you, Your Honor.
Thank you. Thank you, Mr. Freeman.
Yep, thank you.
Why did I didn't pass this. What happened? Did she turn in a green sheet?
Yes. Yeah.
Just a dish stick? Oh, okay. I thought she was writing a novel or something. Yeah, I held the file it's like we were gonna get it because you just no. I thought she was still writing. I didn't know. All right, fine. We'll get it to the file. Court does call the case of the People versus Danielle Presley.
Public Defender Hannah Apple appearing on behalf of Ms. Cressy, who is appearing via Zoom.
Hello. State your name.
Hi.
please.
Danielle Presti?
Thank you. Your Honor, we did complete our mitigation information and that's been provided to the people, to my understanding. We're asking for an adjournment for some continued negotiations.
Probable cause conference, September 25th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you.
Court does call the case of the people versus Kyrie Raymond.
Alexander on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Raymond, who's approaching now. You state your name for the record.
Kyrie Raymond.
Your Honor, we're asking that this matter be set for a preliminary exam.
Discovery is complete.
To our knowledge, yes.
We will have their witnesses available the 16th. Preliminary examination in person, September 16th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you.
Thank you. Court calls the case of the people versus Malik Reynolds.
Assistant Public Defender Hannah Apple on behalf of Mr. Reynolds. There he comes. There he is. There you go.
Ready, Judge, Torshell Feaster, Assistant Public Defender on behalf of Mr. Reynolds.
You're starting to get like acting early and can't.
Apologize.
All right, no problem.
Didn't know you were on the bench. State your name for the record.
Hello, Your Honor. My name is Malik Montel Reynolds.
Hello.
Thank you, Judge. I was just speaking to my client and he has asked me to set this matter for preliminary examination. I believe our discovery has completed.
We'll have the witnesses available the 16th. Preliminary examination in person, September 16th, 2025, 9 a.m. before Judge Perry. Bond will continue. Thank you.
Thank you, Judge.
Court calls the case of people versus Emmanuel Rhodes.
Assistant Public Defender, Tanazi Carey, I can really, Your Honor, on behalf of Mr. Rhodes, read your, state your name for the record.
Emmanuel Rhodes.
Your Honor, we're asking for an adjournment. We want to provide some mitigation information to the people.
All right. That objection, probable cause conference, September 30th, 2025.
I'm good.
9 a.m. That's a Tuesday.
That's the 25th. Thank you so much, Your Honor.
No.
Good tell you.
Seriously? What did you just say to me?
I was asking, confirming the date was the 25th.
Is that what I said?
Is that what he said?
No.
I don't know what you said.
Don't take it, bro. These was me. Did you actually hear the 25th?
I thought I did. It wasn't the 25th.
Probably get that checked out.
Oh.
All right. September 30th.
Okay. 30th.
That's a Tuesday.
Okay.
2 o'clock.
I said it at 9 a.m. but We'll give you a time block.
Okay.
Your attorney will let you know what time you show up.
Yep.
Thank you. Court calls the case, people versus Dion Richmond.
Trevor Maybell for the people, Your Honor.
Ron Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Richmond. Then I have paged the courtroom for Mr. Richmond. I have not received a response. However, maybe at the CVS gas station pharmacy getting some sushi. So I think, Your Honor, if we adjourned it.
He could be there or traveling along M14. Running in the stop sticks.
If we adjourn it, Your Honor, we can find out for sure if we adjourn it.
two stories today that made no sense. They, just saying. I'm trying to give you the benefit of the doubt. Bench warrant will issue bond 10,000 cash surety.
Thank you, Your Honor.
That warrant will issue. Court calls the case, People versus Alexa Rushing.
Assistant Public Defender Alexis Dirks on behalf of Ms. Russian, who should be appearing via Zoom.
I'm sorry, I'm here.
Can you state your name, Ms. Russian?
Yes, Alexa Russian.
Yes, I see.
Your Honor, APA Douglas just reached out and said we had something worked out. She forgot to send over the paperwork. So if we could get a quicker date, I think we could get this resolved relatively shortly.
Sure. You want to be 1 or 200? I don't care. Probable cause conference, September 18th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
You're welcome. Why'd you throw Miss Douglas under the bus? What? Wow, serious? We need to talk to Ally. Ally never takes blame for anything. No blame, no responsibility. It's somebody else's fault. Court calls the case, People versus Ricky Sample.
Court shall cease to assist the public defender on behalf of Mr. Sample, who's approaching the podium.
Hello, sir.
Please.
Hey, how you doing?
I'm doing great. What's your name?
Ricky Sample.
Thank you.
Your Honor, I have a chance to speak to my client and the prosecutor, asking for a 2-week adjournment so that Mr. Sample can review the discovery in this matter.
September 25th, 2025, 9 a.m. I'll need a green sheet. Bond will.
Thank you very much, Judge.
All right. Court does call the case of the People versus Jeffrey Sanders.
Ally's in on behalf of People.
And Bishop's on the run. This is Miss Yagi's case.
Assistant Public Defender Hannah Apple on behalf of Mr. Sanders.
Lord, yeah, Assistant Public Defender with and on behalf of Mr. Sanders. Mr. Sanders, come on. And I do not have a green sheet prepared, but I will get the court one, Your Honor. I am, I'm sorry. Please state your
Jeffrey
name.
Sanders. Thank you.
Your Honor, we were having conversations. We need more time to continue conversations about this case, so I am asking for an adjournment.
Without objection, probable cause September 30th, 2025, 9 a.m. That's a Tuesday. Bond continue.
Thank you. Thank you.
Thank you.
If you think it's a Tuesday, you can check with Ms. Akinrelli. She'll be the attorney. Court calls the case, People versus Ashley Shepherd.
Ashley calls us with the People.
Assistant Public Defender Alexis Dirks with and on behalf of Ms. Shepherd, who's appearing via Zoom. Can you please unmute and state your name for the record?
Ashley Shepherd.
Thank you, ma'am.
Your Honor, we are awaiting some media discovery on this matter, so we'd be requesting an adjournment.
Probable cause conference will be adjourned September 30th, 2025, 9 a.m.
Thank you, Your Honor.
Bond
Thank you.
continued. That's a Tuesday. You're welcome. Court does call the case, People versus Brandon Sims.
Trevor Mayville, the people here.
Lori Yagi, Assistant Public Defender with and on behalf of Mr. Sims. Mr. Sims, could you state your name for the court?
Yes, Brandon Sims.
Thank you.
And Your Honor, I am asking for an adjournment. I do not have a green sheet prepared yet, but I will get one to the court. I believe Mr. Sims may be preliminarily, hopefully eligible for the SAS program. So I'm going to try to figure that out. So that's why I'm requesting an adjournment.
Probable cause conference will be adjourned September 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you, sir. Court calls the case of the People versus Devon Watson. Why did they call his case?
Trevor made up for the people you're on.
Tim Rogers on behalf of Mr. Watson.
No, in all honesty, that's not the reason why, but you might have to. This attorney was just in Zoom, but now they're not there. Because that's how it's going today.
Okay, it's all right.
I know.
Go ahead.
Can you please say your name for the record?
Davon Watson.
Can I get you something right here? You okay?
Been a long week, Brian.
Wow.
I'm on her.
That douche, I don't know what she did. What?
He hired a private attorney, but I don't think the substitution's in. So for now, we are going to be asking for an adjournment for that to go through and for him to be able to talk about it with his attorney.
Well, what was Eileen was just explaining, he or she was in Zoom
No longer there.
and they're not there, and I don't have a substitution of attorney.
Yeah.
I only have an appearance.
I'll still ask for an adjournment and then hopefully
Of course
that.
you will. Because it's what I do. I'm kidding.
I know.
No, I'm not. Do you know the availability of your attorney or?
Not yet. I don't know yesterday.
Oh. Okay. Well, let's do this so that. Set it for September 18th, 2025, 9 a.m. Bond will continue. Okay, so let them know that's the date I set. And while you may not know what this means, that I need a substitution of attorney filed.
All right.
And not just their appearance. All right, young man, thank you.
All right.
Thank you.
They signed,
Oh, okay, I'm letting them in.
they just signed in. Not that they're really on the case, but. Yes, ma'am. Court recalls the case, people versus Devon Watson.
Can I on behalf of Mr. Watson?
Counsel, if you want to state your appearance.
Monty Kavajan, are you talking to me, Judge? I know.
Yes, I am talking to you.
Monty Kavajan, on behalf of Mr. Watson, P76143.
All right. So first thing, I adjourned this out to September 18th. As of right now, the public defender is still the attorney of record because I need a substitution of attorney filed.
Okay.
All right.
Absolutely, Judge. We'll get that to you right away.
All right. Bond continue. Thank you.
Thank you so much.
Thank you. Court does call the case, people versus, is it Unai Singletary?
People.
Portion of fees to Assistant Public Defender on behalf of Ms. Singletary. Ms. Singletary, if you could unmute and state your name for the record.
Unai Singletary.
Thank you.
Thank you, Judge. We have been in discussions trying to resolve this matter. Ms. Singletary is asking for a brief adjournment to see if it's possible to find a higher resolution on this possible.
Probable cause conference during September 18th, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you.
Thank you. Court does call the case, people versus Joseph Smith.
Assistant Public Defender, Chinazi Kiriakin can rule, Your Honor.
Is that a surprise? Or?
On behalf of, unfortunately not with Mr. Joseph Smith.
But do you think if you talk to me slower, they'll show? No, go ahead.
As
Go
much
ahead.
time.
I'm sorry.
Judge, unfortunately, I do not have an explanation to the court as to why Mr. Smith is not present today.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety.
Thank you, Judge.
Your Honor, I don't know, maybe this isn't giving up. Mr. Smith has another case that's in front of Your Honor for exam on the 23rd. It's a continued exam. Does he get picked up before then?
He has an exam before me on the 23rd?
That's what I had on my notes. So we started and then there was a discovery issue. And also had this new case. And so you set it out on the 23rd. The idea that that would be resolved and this case could catch up with that.
Ooh.
Jennifer.
Joseph Smith. Is he on?
I'm verifying, but yes, that's right.
So he's set before me for exam on another case. And I seem to recall kind of what you're talking about on this one.
If you gave him a week to turn himself in on the new case, which I guess he did.
Yes, and didn't show up. Of course, I didn't give him all the instructions, right? I mean, tell you what I'll do. Instead of issuing the warrant in this case, secondarily, I'll set that's set for the 23rd. So let me push this case out. I'll set it for the 18th. I'll adjourn it out.
Thank you, Your Honor.
Don't thank me, thank Ms. Douglas.
Thank you, Ms.
Because she could have let
Douglas.
that bench warrant roll.
Thank you, Ms. Douglas.
September 18th, 2025, 9 a.m. See, she'll take the blame for something that's her fault, she says. But then she wasn't going to take the credit for this. So I'll give her the credit. His bond will continue at this point. Thank you, Ms. Douglas. Court does call the case of the people versus Leilani Smith.
National Felons for People.
Public Defender, Chennazi Carey, on behalf of Ms. Leilani Smith, who's approaching. If we're asking for an adjournment today on Ms. Smith's matter, we'd like to, she's given us some information to put together in a mitigation report to offer to.
Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Bond continued.
Thank you.
Okay, so the people versus Emmanuel Sneed.
Public Defender Hannah Apple appearing on behalf of Mr. Sneed. Should be appearing via Zoom.
Oh, there he is.
Mr. Sneed, will you state your name for the record?
Need to unmute, sir. Need to unmute.
Hello, I'm sorry, sir. I'm sorry, Your Honor.
That's
Emmanuel
okay.
Sneed.
Thank you.
Thank you. Your Honor, we are asking for an adjournment. We had previously adjourned for video discovery. We did receive confirmation that due to a retention policy, no video was saved from this matter. So I need to discuss that with my client and then Ms. Feltus as well regarding resolution. Potentially.
Probable cause conference will be adjourned September 18th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls case people versus Jay Snyder.
Assistant Public Defender, Chennazi Carey. Your Honor, on behalf of Mr. J. Snyder, who is approaching, Mr. Snyder?
Yes.
Is you, okay. So, Your Honor, Mr. Snyder informs me that he's retaining private counsel in this matter. I see counsel is coming.
Good afternoon, Judge. How are you?
Do I have a substitution?
Judge, I just met with his mom out in the hallway. I've known her for years and they.
What?
I met with his mom out in the hallway. I've known her for years and they are retaining me. I haven't been retained yet, but I know his mom well enough that I trust her. So I could submit all the proper pleadings by tomorrow to the court, a step in order to sub
So the
in.
answer to my question is no. I don't have.
Oh, I'm sorry. No, I do not. I'm sorry for the long story.
No. Just gonna wait till you finish.
I'm done.
All right.
So if we could adjourn it, that would be great.
I need a green sheet.
Green sheet.
Don't worry about it.
Green.
They'll sort it out.
There it is.
Just get that to me. I'll adjourn it out. Probable cause conference will be adjourned to September 30th. Will that work?
Judge, can we put it to the middle of October? I just spoke to the mom and she drives him everywhere. She's gonna be out of town until the 4th of October. So if we do it anytime after that, that'd be great. I know, I come in here, I'm
Don't have any objection to.
demanding.
No, Your Honor.
Thank you.
Really?
I'm not about to tell this court how to schedule.
No, I know, but you could have had an objection. You could have just said it. It didn't mean I was listening, but you could have said it. Fine, never mind. Never mind, Cook. October 9th,
Okay.
2025, 9 a.m.
Thank you, Judge. I'll fill this out and hand it to your
Fine.
staff.
Bond will continue. Actually, if she's going to retain you, they can help you with the substitution right now. In fact, Ms. Akinruli would be more than happy to sign off on this.
That would be great.
Well, that's the green sheet,
Yes,
so.
I'll get the substitution to him.
Okay,
Thank you, Judge.
you're welcome. Sir.
You had that ready to
Case
go.
People versus Danielle Stewart.
Come on.
Assistant Public Defender, Chenal Vikky, Your Honor, on behalf of Ms. Danielle Stewart, who should be on Zoom.
There she is.
Yes.
Hello. Good afternoon.
Really? Yeah, she is.
Ms. Stewart, state your name for the
Thank-
record, please.
Danielle Stewart.
Thank you.
And Judge, we're asking for an adjournment in this matter. We needed an opportunity to speak with Ms. Stewart and review all of the discovery.
Probable cause conference, September 25th, 2025, 9 a.m. Bond continued.
Thank you. Have a good day.
You're welcome. You do the same. I bet you we can't read it. Court does call the case People versus Michael Stone.
Assistant Public Defender Jay Bellinger on behalf of, but not with Mr. Stone. Your Honor, as this court is aware, Mr. Stone is at Harbor Light. I was able to speak with him yesterday. I was also able to speak with a social worker, but I was not provided an email by which I could get a Zoom for him in time. He is due to be released from Harbor Light on the 15th of September, so we would just ask for a date past that point.
Any objection to an adjournment? See, this is how it's done, Mr. Cook.
I can object on that.
No, I'm just saying, this is how it's done. You like agonize over it. She's gonna stand, dramatic kind of standing. Everybody here is waiting. Mr. Bellinger has no clue what she's gonna do. Nobody does.
Leave in the court's discretion while making it. He did fail to appear.
Yeah, I know, but I think we figured out why.
I hope so.
Wow.
We did provide the proof. I'm just.
Okay, don't do that. I'll grant an adjournment in this, and he's supposed to release on the 14th, you said, or
15th, Your Honor.
15th. So let's adjourn it out in September 18th, 2025, 9 a.m.
Thank you very much.
And I'll issue the warrant. Court calls case People versus Khalil Taylor Jefferson.
Hey, Judge, to show the Assistant Public Defender on behalf of Mr. Taylor Jefferson, who should be approaching the podium. Mr. Taylor Jefferson, when you get here, please state your name for the record.
Khalil Taylor Jefferson.
All right.
Thank you, Judge. I have to provide the court with a waiver. My understanding is Mr. Taylor Jefferson has been, is trying to get into the drug treatment court.
Got it.
Court, Your Honor.
All right. So, sir, you understand you're waiving your right to a preliminary examination?
Yes, sir.
You know, that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Thank you, Judge. We waive formal reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
October 29th at 1:30 with Judge Conlon.
October 29th, 2025, 1:30 before Judge Conlon.
Thank you very much, Judge. 10:29.
Bond continued. Court calls the case, People versus Jeffrey Thompson.
For those for the people.
Assistant Public Defender Alexis Sept with and on behalf of Mr. Thompson, who's approaching the podium. Can you please state your name for the record?
Hi, it's Jeff Thompson.
Thank you.
Your Honor, we're requesting an adjournment to continue discussions with the people.
Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Joanne Thompson.
And Assistant Public Defender Jay Bellinger on behalf of Ms. Thompson, who approaches, Your Honor. Ms. Thompson, can you please state your name for the record?
Joanne Thompson, Your Honor.
All right, thank you.
And Your
Thank you,
Honor, we are just asking for an adjournment today. Ms. Thompson advises that she's going to be doing intake with Don Farms for their outpatient program on the 10th of September. And we are just asking for an adjournment for a few weeks out so we can start tracking her progress on that in hopes for a resolution in this matter.
And you see her progress report.
I have seen the progress report, Your Honor. And I have been able to review that with her as well.
So, ma'am, if I were to test you today, what would show up?
Probably still just some marijuana. That is it, sir. I can go test right now if you would like. I know it takes a while to get out of my system, so I don't know. It could still be there, it could not. I don't know.
You have a medical marijuana card?
No, I'm in the process of getting that though.
Of course, everybody is.
They asked me to do the drug treatment. We were gonna do intake this next Monday on the 8th, but I'm going up to St. Helens to bury my spouse that day. So Mr. Brown said I could do it the 10th, so we have it scheduled for the 10th here at Community Corrections is when I'm meeting Don Farms.
I want you to go over and test.
Okay,
Right. Then we'll decide what we're gonna do.
Yes, sir. Understood.
all right, so go over, test and come back.
Yes. Yes,
Okay,
ma'am.
okay.
Court calls the case, People versus Shaquise Tillison.
Brian Bowling on behalf of Ms. Tillison, who is approaching.
Jacquees Tillison.
Your Honor, this is the third PCC in this matter. I spoke to Ms. Tillison. We don't have any video footage related to this incident at all. However, and I did speak to Ms. Is it Feltus about that today. I just was confirming her last name.
Which is what?
It's Feltus.
Oh. Okay.
About that. So we're trying to get that ironed out, Your Honor, but Ms. Tillison would like me to request that this matter be set for an exam today. So that's what I'm going to do based on her request.
All right. And so there is no video, or?
We don't have it. I believe there most likely is.
I emailed with the sheriff's department today to try to track it down, because it's weird that we don't have it. They're very quick and very good about it. They had sent us a case with a 2024 video with the same like police report number for 2024. And I was like, hey, actually this is for 25. And they were like, we don't have any, but the report contains a still shot from a body camera. So I reached out to the actual deputies who were on scene to see if I could track down. Maybe it's saved under a different report number. Every once in a while that'll happen. They never call for service number. So I'm going to see if I can try and find it before then. But right now we do not have it.
You understand, ma'am, that if since you know that it may exist, but it isn't here, that if I set this for exam, you're not entitled to an adjournment based upon the fact you don't have it.
Yeah, I understand that.
You do? Okay. People would have their witnesses available the 16th.
We'll try, Your Honor.
Preliminary examination in person, September 16th, 2025. 9 a.m. before Judge Washington.
Thank you.
Thank you.
In touch.
Court calls case, People versus Beverly Joe Tuttle.
Trevor Mayville for the people, Your Honor.
Just what'd you say? I just wanted to say that. What'd you say?
I'm the only one you say my full name.
I saw it and I said, you know, if I
Good
put a little country
afternoon,
accent on
sir.
that, I'll be Beverly Joe Tittle. All right.
Not as country as it sounds.
Not a country, okay.
Good afternoon, sir.
Chelsea
afternoon.
Vergils with and on behalf of Beverly Tuttle, can you state your name?
Beverly Tuttle.
Your Honor, we are asking for an adjournment. I don't think it's been confirmed yet, but I think we might have a conflict in this case, so. she
I
is a new
can't figure
attorney.
it out. Okay.
And then she does have a couple other cases set for next Thursday. However,
Or before me
I believe so,
on-
yes.
on the 11th.
Yes, however, I believe she will be in inpatient treatment at that time. I don't know if it's possible for you to move all the cases another week out or just set this one for the 18th, but she will be in treatment.
Okay, I got you. So here's what I'll do. Your other cases are set for the 11th.
Okay.
So let me adjourn this one to the 11th, 2025 at 9. She gets in treatment, then you can by step, if you let us put that in the body of the stipulation, we'll move all of her cases to another day.
Okay.
Yes, ma'am. You want to say something?
Thursday, the 11th, I'm actually scheduled at 10:30 to be in Judge Conkey's court. Recovery. Court,
Okay.
At 10:30. So
Well,
if I
think you're
have
going to
it-
be in treatment.
I meet with Dev Tuesday at Dawn Farm. I met with her today and we didn't have the full 2 hours available to do the full assessment. And
Got
so
it.
we rescheduled to this coming Tuesday, and we're gonna do the full referral.
Got it.
And the objective is for me to go to Sparrow. And then from Sparrow, go to transitional.
Okay, so here's what we'll do. Keep in contact with your attorneys. They'll know where you are. If you're down before Judge Conkey, fine, we'll deal with it.
Okay.
I just need to get all of your cases together.
Exactly.
Then we can go from there.
Perfect.
Fair enough?
Fair enough.
All right. So the 11th at 9 a.m. bond in this matter will continue. All right, thank you.
Have a blessed day.
Court does call the case People versus Michael Umber.
Good afternoon, Your Honor. Raymond Cook for the people.
Judge, Portia Feast to Assistant Public Defender on behalf of Umber, who I'm told might be on Zoom. I don't know if that's him or not. There was a person there a minute ago, Judge.
That was so like, I'm hopeful somebody told me.
So I received a message by Teams that Mr.
Pardon?
I received a Teams message from our office that Mr. Umber had called and that he was in a court hearing in Ferndale and he was gonna jump on Zoom as soon as that ended. So I was hoping that Samsung might be Mr. Umber, but apparently it is not.
Well, it might be. I don't know what Mr. Umber looks like. Hello, Mr. Umber? No, that's not him.
Not him? Okay.
He didn't respond.
No, he did not.
So you think you can stay up here long enough to sign in?
I don't think so, Judge. For the record, I will request an adjournment. If the
Who
court,
sent the Teams message?
Sunana, one of our legal clerks at the office.
She reliable? Never
Normally.
mind. Don't answer that. Just saying.
If the court does issue a warrant, then I will do a recall and try to provide proof of the court date.
Bench warrant will issue bond 10,000.
Thank you, Judge.
Cash surety. That warrant will issue. Court does call the case of the people versus Marion Watson.
And on behalf of the people.
Brian Bowling on behalf of Mr. Watson.
Oh, that's a lot of mayonnaise. Who's
That is a lot of
doing?
mayonnaise. Good grief.
That's a lot of mayonnaise, man. That's not heart smart. Wow. Oh, okay, I got you. All right, you're good. Keep going. We'll just see what you're making. Okay. Yes. All right, record should reflect we've had a bench conference in this case. Although the defendant is not here, I will adjourn the probable cause conference. I'll just adjourn it out a week to September 11th, 2025 at 9. Bond will continue.
Thank you, Judge.
Thank you. Court does call the case, People versus Andrew White.
Was that really on what?
What?
What was the name? Sorry. Andrew White.
I'm just not paying it, they can't hear over there?
Assistant Public Defender Chelsea Redeals with and on behalf of Andrew White, who should be on Zoom, please state your name.
Andrew White.
You got on mute, we can't hear you.
Mr. Mayo.
Hi.
Andrew White. There you go. All right.
Your Honor, we're asking to adjourn. We have yet to receive media discovery.
Oh, you need media also. All right. Probable cause conference will be adjourned September 25th, 2025, 9 a.m.
Your Honor.
Bond will continue. Yes, sir.
For the record, it's egg salad.
Okay. It had to be something like that because that was a lot of mayo. Man, it's like, okay,
two
no,
tablespoons.
you're good. You're good because I didn't know. I'm like, you put that much mayo on a sandwich? I don't know.
Thank you.
Take care.
You as well, sir.
Court calls the case, People versus Jeremiah Williams.
Ashley Bell is for the people.
Okay, so where did all the PDs go?
Judge, I'm right here, Assistant Public Defender Hannah Apple, appearing on behalf of Mr. Williams.
That
appears to be assigned to Miss Pate, who is not on.
Mr. Eastover, you really did get that small when you did that, but that's okay. No, it's all right.
Is there a Jeremiah Williams? Judge, I'm happy to look in the notes, but I do see it was assigned to Miss Pate and she's not on PCCs today. I don't know that we've had any contact or what we've informed him of his court date. The court would, based on that issue being our office's fault, I'd ask for an adjournment.
Here's what I'll do. I'll issue a bench warrant for his failure to appear. 10,000 cash surety. I will not issue that warrant until I won't issue that warrant until the 9th.
9th. Okay, thank you, Judge.
Court does call the case of the People versus Damian Williamson.
Good afternoon, Your Honor. Raymond.
And Assistant Public Defender Hannah Apple appearing on behalf of Mr. Williamson, who's approaching now. Mr. Williamson, will you state your name for the record?
Damian Williamson, Your Honor.
Thank you.
Your Honor, I am asking for an adjournment for some continued plea negotiations, and I did wish to address one component of bond.
Probable cause conference will be adjourned to September 30th, 2025, 9 a.m. or as your invite indicates, that is a Tuesday. So go ahead. Yes.
Thank you. Your Honor, this Mr. Williamson is charged with a single count of resisting and obstructing a police officer in this case. The magistrate at arraignment ordered a no contact with Mr. Williamson's the mother of his child. They have a child in common. The officers were called to the scene for family dispute involving I think that one of the parents called, if I'm remembering correctly, the police.
One of the parents.
It would be his ex's parents.
Got it.
They're all at their house. So police are called out. There's maybe a report of like a delayed domestic, but ultimately it's determined that whatever that is that happened did not happen in Washtenaw County. The officers here don't kind of pursue that as it's not their jurisdiction. And to my knowledge, no charges have been authorized elsewhere. At the arraignment, there was a no contact order placed with this individual, his ex, who they have a child in common. It's my understanding and belief that that was not her request. I know
That was
that
not what?
that was not her request to not have contact. I know that there were some statements made to police on the body cam footage that could potentially support that, but we are asking the court to consider lifting that, as there's the basis of this charge is not related to that individual. He is not charged with any crimes or assaultive crimes related to that individual. That's the information I have. I did speak to the prosecutor's office and asked if they received any confirmation. I don't believe they have that in their file.
So, Your Honor, we did charge actually back in January, complaint charging count 1, assault, intent to do great bodily harm or by strangulation, count 2, domestic violence, count 3, malicious destruction, 1 to 20,000, with the named individual that defense counsel is referring to. That was authorized back in January. From my understanding, YPD still has not sworn to that. I don't know why. Based off the court's expression, I imagine the court has some sort of understanding, but I'm concerned,
I have my
I'm
thoughts.
concerned about lifting the no contact order given those other charges.
May I respond?
Yes.
Your Honor, I mean, it would be defense's position that if allegations happened in January, we are now into September. My understanding is they've been having a co-parenting relationship. I don't know, we don't know whether or not that swear to is going to happen, if the magistrate's going to be able to find probable cause. I think that that's a far stretch to continue this added dynamic for their co-parenting relationship, when right now, Mr. Williamson's before the court on a single count of RNO.
Okay, here's what I'm gonna do. I'm gonna move the probable cause date up to the 18th. Has anybody contacted YPD regarding?
I have not yet, but I can immediately after.
Okay. So what I'm gonna do is I'm going to, at this point, deny your request because there's a lot that's out, sir.
It's okay. Hey.
Just listen to everything I'm gonna say because I'm trying to. So I'm gonna deny the request, but I'm moving his case up about 2 weeks. It's closer, okay? I will address it then, but I need the prosecutor to make a call to YPD. If they're gonna swear it out, then swear it out. Let's deal with it. But if they're not going to, then I can deal with
Okay, hold on.
what's in front of me.
Ask me first.
Okay?
Yeah, no, it's okay. We can't, that's fine. All right, thank you, Judge.
Bond will continue. I wouldn't act that way because I can just rule right now.
Sorry.
Sorry.
Thank you. Court calls the case, People versus Ilian Woods.
Mr. Woods, Ilion Woods. Ashley Phelps, people.
Cameron Dadish on behalf of Mr. Woods, who should be on the Zoom.
The Zoom, like,
Mr. Woods, can you please state your
is
name for
that
the
like the Facebook?
No, we're.
Is that like, no, never mind.
Can you hear me?
He's there.
He's good?
Yeah.
Your Honor, we're just gonna be asking for an adjournment. I believe there's outstanding discovery that we need on this. We do have some of it, but I believe there could be more.
Probable cause conference will be adjourned to September 30th, 2025, 9 a.m. That's a Tuesday. Bond will continue.
Your Honor.
Thank you. Court calls the case of the People versus Lauren Marie Michaels.
Ready, Your Honor.
I beg your pardon, I missed the name. Is this Ms. Michaels?
Yes, it is.
Yes.
Trevor Mabo for the people.
Good afternoon. May it please the court. My name is Matt Savage. I represent Ms. Michaels. She's appearing today via Zoom. Thank you for allowing that, Judge. Your Honor, we're asking, well, I'm asking for.
Ms. Michaels, could you state your name, please, for me? Oh, you're muted. There you go. Thank you.
Thank you, Judge. Respectfully, I'm going to ask the court for one last adjournment. I have, my client is presently in Pasadena Villa. It's a residential facility over there in Battle Creek. There's attempts to try to get into a long-term facility right now. So I'm hoping that I'll have some information on that within the next 12, 14 days. I'm asking the clerk if we could put this over till October the 19th. And also, I've dealt with
Yes.
Mayville today, and I need to provide him with some information.
Council approach.
Yes.
All right, record should reflect they had a brief bench conference in this case. I will grant the request for an adjournment, and I will adjourn this to, it's October 16th,
Thank you, Your Honor.
2025, 9 a.m. Bond will continue. Thank you. Thank you, Ms. Michaels.
Thank you, sir.
Court calls the case of the People versus Brock Gerard.
Yes, Your Honor. Good afternoon.
I've felt this with people.
Good afternoon, again, Your Honor. Stephen Moss on behalf of the defendant Brock Gerard, who is now standing to my right. Identify yourself, please, for the court.
Brock Gerard.
Thank you, Your Honor. This is the day and time scheduled for a probable cause conference. I have spoken with prosecuting attorney, and I am asking for an adjournment. Schedule another probable cause conference.
Will Tuesday, September 30th work for you, sir?
It does, Your Honor.
Probable cause conference adjourned September 30th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you.
You have a good day.
You do.
Good to see you.
Court calls case of the People versus Kimberly Baumgartner.
There you go. Government people, Your Honor.
Good afternoon, Your Honor. Chris Eastup appearing on behalf of and with Kimberly Baumgartner. Baumgartner, you state your name for the record.
Kimberly Baumgartner.
Okay. And I have before me a plea form that indicates that she's going to count 2 of.
It's not added, Your Honor.
It's not,
it's
she's
just
pleading count 2.
Yep.
The OWI high BAC. And count 1 would be dismissed. That's the court's full understanding of the agreement.
Thank you, Your Honor.
That's accurate, Your Honor.
Okay. May I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Kimberly Baumgartner.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating with a high BAC. That is a misdemeanor, punishable by up to 180 days incarceration, up to a $700 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized and could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Correct.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty?
Yes, sir.
January 24th, 2025, at the location of Oak Valley Drive near Boulder Ridge Drive in Pittsfield Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
I did.
Do you recall what you had and how much?
About 7 beers.
All right. Were you stopped by the police?
Yes, sir.
All right. Why'd they stop you?
Because I went through a red light.
All right. You're not challenging the right of the police to stop you in this instance, are you?
No, sir.
All right. Were you ultimately arrested?
Yes, sir.
Were you taken to the hospital or were you taken to the police station?
The hospital.
All right. Was there a blood draw?
Yes, sir.
And what were the results of that blood draw?
0.24.
Okay. You have any reason to dispute those questions yourself?
No, sir.
All right. Ma'am, if between the time I accept your plea and the time of your sentencing, you commit misconduct as defined under the Michigan court rules, you would not be permitted to withdraw your plea. You understand that?
Yes.
And also, any evaluation, which there really isn't any, or recommendation, the court would not be bound by. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, sir.
And from the defense.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, yes.
Defense is satisfied.
All right, court will accept the defendant's plea of guilty to count two. Count one is dismissed. Defendant's referred to probation and a screening and assessment through Von Swartz.
Your Honor, would the court accept Mr. Statman's assessment? She got one done by Mr. Statman already.
If it's going to be acceptable to probation, I'm not gonna have a problem. But I will make that referral in case she needs to do that. Sentencing in this matter will be
September 24th at 9 a.m.
September 24th, 2025, 9 a.m. Before me.
Thank you, Your Honor.
Thank you. Bond with its conditions will continue.
Your Honor, can I state one thing for the record, just to be
Sure.
careful? So my client works for the University of Michigan Marching Band, and she's sometimes down.
Band?
The marching band. You may have heard of them.
No.
It's not the Maryland, it's not the Maryland.
It's not the
Marching Band,
Maryland, yeah. It's not
the
the
goofy
sound of
uniforms,
Maryland, but that's okay. The second rate band. Okay, go ahead. No.
Good freshman quarterback. Your Honor, so she is down at the field, and as the court is aware, sometimes it's hard to get a signal, and she's on her bond with her
when she's
sobriety unit. And so sometimes it's hard to get the out. So she videotapes her phone, because I've made her aware of this, that she can't miss or be late for tests. So sometimes it's hard for her to get the signal out. So she videotapes all the time when she has to do that. But I just want to be the court aware if it's a Saturday morning, it's a Michigan game home, that could be one of the reasons why, because the cell phones aren't working really well down at the stadium.
Got it. Okay. And she's obviously there for longer than the window period.
Correct.
Got it. Okay. Thank you for letting the court know that. All right. And the band is okay, ma'am. Court does call the case of the people versus Jamie Villalobos. Nate?
Yes.
Alexander, on behalf of people.
Chris Eastop on behalf of Mr. Villalobos Panate. Mr. Villalobos Panate, would you state your name for the record?
Jamie Villalobos Pinate.
All right. All right.
Your Honor, I had a chance to review medical records associated with this report, as well as a supplemental report we received. And at this time, based on the review of those, we would be unable to proceed and would be moving to dismiss count one and would ask that count two be removed down to district court.
Count one is dismissed. I will continue the defendant's not guilty plea as to count two. A pretrial will be set. The D 14B. We don't have a DB there. What I'll do is, if you'll wait, Mr. Easthope, I'll continue as bond. I'll give you a date momentarily as soon as we get communication 14B.
That's great.
And then you can communicate that to your client.
Can he get off the Zoom right now, or would you want him?
Yep, he can go.
All right. I mean, you can disconnect now, and I'll get the date for you and let you know.
All right. Thank you.
Thank you, sir. Thank you. Court does call the case of the people versus Kyle Bailey.
I should call the people.
And Your Honor, Joe Simon, on behalf of Mr. Bailey, state your name when you get up here, Kyle, please.
Kyle Bailey. You're waiving your right to preliminary examination?
Yes, sir.
All right. You understand that's a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Sept.
Wait for reading the information. You understand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for October 27, 2025, 1:30, Judge Hamud.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Ron, continue.
Don't need to wait.
Court calls case of the people versus Madden Delaney.
Trevor Maybell for the people, Your Honor.
Your Honor, Joe Simon on behalf of Mr. Delaney is making his way. State your name, man.
Madam Delaney, Your Honor.
All right. Have before me a plea form that indicates that defendant will be pleading to counts 4 and 5, count 4 being attempted resisting and obstructing the 1 year, and count 5, the offense of operating while impaired, the 93-day offense. Upon a successful plea to those charges, guilty plea to those charges, counts 1, 2, and 3 would be dismissed. And there's a sentence agreement that count 4 will be treated under the Homes Youthful Trainee Act, although I can't bind the court to that. All right.
That's correct, Your Honor.
All accurate, Your Honor.
And have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes, Your Honor.
Madam Delaney. All right. Sir, it is this court's understanding that you're going to plead guilty to 2 misdemeanor charges.
Yes, Your Honor.
All right. First charge is that of attempted resisting and obstructing. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
The other charge is operating while impaired. That is a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court cost. The court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized. Could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. You also need to understand, sir, that while I'm taking your plea, I would not be sentencing judge in this case, and you would be sentenced before Judge Perry in the 15th District Court. Do you understand that?
Yes, Your Honor.
All right. And again, still wish to plead guilty
Yes, Your Honor.
to the charge of attempted resisting and obstructing. How do you plead?
Guilty.
To
Your
the
Honor.
charge of operating while impaired. How do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form. Is that correct?
Yes, Your Honor.
Any question regarding those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of these offenses?
Yes, Your Honor.
On the date of March 16, 2025, at the location of Maynard Street near East William in the city of Ann Arbor, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
Do you recall what you had and how much?
It's about 5 shots of vodka.
Okay. Were you stopped by the police or was there an accident?
I was stopped by the police.
Why'd they stop you?
Just parked in the middle. Yeah, I was parked a little bit bad on the side of the road.
Well, in the lane
Yeah.
of travel. Yeah.
That's bad. Okay. So you're not disputing the right of the police to stop you in this case, are you?
No, Your Honor.
All right. And were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital or to the police station?
Police station, Your Honor.
And was there an intoxicator given?
I had a breathalyzer and I blew a
Yeah.
.12.
0.12?
Yep.
You have no reason to dispute those results, do you?
No, Your Honor.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. When you came into contact with the police, what happened?
There's a little bit of a altercation and my nerves were brewing.
Tell 'em what you
everything was
did.
going- I ran
lost.
away.
Okay,
Yeah.
but what, a little bit of an, what happened?
He ran away. When,
Yeah.
when you were told you were under arrest, you started to run away. Is that right?
Yes.
They had to chase you down?
Yes.
Yeah, that running away didn't work, did it?
Yeah, no, it didn't.
Yeah, okay. All right. Sir, if I accept your plea to these charges, well, one other question, you knew that they were police officers at the
Yeah.
time and they were performing their lawful duties?
Yeah.
All right. If I accept your plea, if between the time of plea and time of sentencing, you commit misconduct as defined in the Michigan court rule, you understand that you could not withdraw your plea in any sentence evaluation or recommendation. The court would no longer be bound by you. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right. Court will accept the defendant's pleas of guilty to counts 4 and 5. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
September 22nd at 8:30.
September 22nd, 2025, 8:30 before Judge Perry. Bond with its conditions will continue.
Yeah. Right.
How's that?
Don't.
Thank you.
Can if you want. Yeah, sure.
Court does call. Thank you. Court does call the case versus Brian, is it Sabolic?
Sabolic. Your Honor, Joe Simon. Village, state your name.
Brian Sabolici.
Have before me a plea form that indicates defendant will be pleading guilty to 2 misdemeanor charges. The first being operating with a high BAC, the 180-day offense, and also the count 3, the attempted resisting an obstructing police officer, the 1-year offense. Upon a successful guilty plea to those charges, count 1 will be dismissed. There is also a sentence agreement that HIDA as to added count 3 only, that being the attempted resisting and obstructing, and no upfront jail as long as the defendant complies with bond conditions. That is the court's full understanding of the agreement.
Yes, Your Honor.
Mine as well, Your Honor.
All right, may I have him sworn?
You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Brian Sabolici.
All right. Sir, it is this court's understanding as indicated that you're going to plead to 2 misdemeanor charges.
Yep.
The first being the state, is it stated count 2? Yes, stated count 2 of operating with a high BAC. That is a misdemeanor punishable by up to 180 days in jail, up to a $700. What is it, 200 to 500 or $700 fine? I thought it was
200 to 700.
Yeah, I thought it was a maximum of 700. Just correct that here. Up to a $700 fine plus court costs. The court could order rehabilitative services as well as community service. Court could order your vehicle immobilized. Could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes.
Also, that you're going to be pleading guilty to added count 3, which is attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that, sir?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Barr in the 14A2 District Court. Do you understand that?
Yes.
Still wish to plead guilty to these charges?
Yes, sir.
To the charge of operating with a high BAC, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand that giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
Nope.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of these offenses?
Yes.
They provided. June 15th, 2025, at the location of Willis near Rossonville Road, Augusta Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
Approximately half a fifth of vodka.
Okay. Were you stopped by the police or was there an accident?
I was stopped by the police.
Why'd they stop you?
From my understanding, there was a distress call. Someone else had called in and then he was just following up.
Because of erratic driving.
Erratic driving.
All right. You're not disputing the right of the police to stop you in this case?
No.
All right. Were you ultimately arrested?
Yes.
Were you taken to the police station or the hospital?
I was taken to the hospital and then police station.
All right. Was there a blood draw at the hospital?
Yes.
And what were the results?
0.401, I believe.
Correct.
0.401.
That's correct, Your Honor.
You're not disputing those blood test results, are you, sir?
No.
When you came into contact with the police, what happened?
He had instructed me to do a couple of tests, and on the last one, I was thrown off guard, and
When you were asked to put your hands behind your back and told you were under arrest, did you resist? putting
yeah, I
it-
resisted
And then tried to pull your
and
hands away?
pulled my hands away. Yeah.
Sir, if I accept your plea, you need to understand that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, the court would no longer be bound by any sentence evaluation or sentence recommendation in the case. You understand that, sir?
Yes.
You would also not be permitted to withdraw your plea. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this case will be
September 30th at 10 a.m.
September 30th, 2025, 10 a.m. before Judge Barr. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you.
Thank you.
Wait.
People versus Anthony Gregory.
Good afternoon, Your Honor. Jonathan Sachs for Mr. Anthony.
Were we done with the Simon show? Oh, okay.
After yesterday, yeah, I thought we came to a nice place.
You know our relationship.
Thank you, Your Honor.
Go ahead, sir.
Thanks. Your Honor, this.
Your name? Anthony Gregory. Thank you.
Thank you. Your Honor, this is a new appointment. I'd ask for a short adjournment so I have a chance to speak to Mr. Gregory and also with Ms. Felte. I'm optimistic.
We all start that way. Anyway, probable cause conference in this matter will be adjourned September 25th, 2025, 9 a.m. or as your invite indicates. Bond continued. Thank you.
Thank you, sir.
Court does call the case of the people versus Ashley Lavelle.
Trevor Mayville for the people, Your Honor.
Good afternoon, Your Honor. Jonathan Sachs for Ms. Lavelle, who is on Zoom.
Ms. Lavelle, can you state your name, please?
Hi, I'm Ashley Lavelle.
iPhone 1, better. All right.
Your Honor, if I can jump in here, it's the people's intention to dismiss this case outright, and I can have that now filed by the end of the day tomorrow.
Any objection?
No objection, Your
Didn't
Honor.
think there would be. All right, case is dismissed. Court does call the cases of the people of the state of Michigan versus Stephanie Melissa Minton.
Trevor Mayville for the people.
Good afternoon, Your Honor. Jonathan Sachs for Ms. Minton, who's on Zoom.
Ms. Minton, can you state your name, please?
Stephanie Manton.
All right, good.
Your Honor, may we approach on this one?
Oh, boy. Yeah, come on. Best conference in this case and courts understand. Request for it. Oh, he's got it.
I've got it filled out.
Okay, that's fine. There's been a request for an adjournment. I'll adjourn the probable cause. I'll grant that. Adjourn the probable cause to September 25th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond will continue. All right. Thank you, Ms. Minton.
Thank you very much, Your Honor.
Thank you.
Got the
Court does call the case of People versus Tierra Williams.
Ready, your notice to the people?
Good afternoon, Your Honor. Deborah Schlossel on behalf of the defendant, Ms. Tierra Williams, who is to my right, state your name. Tierra Williams.
Thank you.
Your Honor, I have a green sheet. May I tender that to the court officer? Your Honor, at this time, we are, I believe, close to an agreement. We are engaged in plea negotiations and we need an amount for restitution. So, Your Honor, I would respectfully request that this matter be adjourned out 2 or 3 weeks.
I'll adjourn the matter to September 30th, 2025, 9 a.m. That is Tuesday.
Thank you, Your Honor.
Bond will continue. Thank you, ma'am. Court does call the case of the people versus Adrian Gehrman.
Good afternoon, Your Honor. Hassan Bazi on P7844 on behalf of Mr. German, who's present on Zoom. Adrian, can you state your name for the record?
Yes, good afternoon, Your Honor. Adrian German.
Your Honor, we do have an offer. We did sign a signed plea offer agreement, but it was a no contest plea, and I'm sorry we didn't submit the police report. So if you can give me a short agreement on this, so I can resubmit everything properly, I'd appreciate it.
Okay. Will the 18th work for you or the 25th? Which one's better?
It'll be in the afternoon though, right?
Yes, on both those days it would. They're in the afternoon at some point.
Whatever you'd like, Judge. The 18th, whatever's good with you.
18th? All right. Probable cause conference, September 18th, 2025, 9 a.m. But it would likely be in the afternoon. Bond in this matter will continue.
Thank you, Your Honor. Have a good day and your staff.
Thank you, Your Honor.
You do the same. Court does call the case, People versus Anthony Alfaro Callejas.
Good afternoon, Your Honor. Attorney Zach Bonham. My client is there in the courtroom.
Good afternoon, Your Honor. My name is Anthony Callejas.
We have not addressed this.
We have not because.
Got it. Okay. All right. All right, what are we doing on this?
Your Honor, I would ask for a short adjournment. We have some ongoing negotiations toward a resolution. There is a minor issue with some discovery that I assume are going to be taken care of very quickly. So we just need a short adjournment.
Have you received the bond violation report, counsel?
I have, Your Honor.
You have?
Yes, I did. I received it last night from your office.
Okay. This is probably more of a problem, Mr. Allen. Does he wish a hearing on this? I mean, I've got August 14th, he's positive for alcohol with the high being a 0.07. And then on the 20th, he is also positive for alcohol at a 0.06, being the high, and then failure to take his retest on that. He is just missing tests all over the place, not testing timely, but then not retesting. And then on August 29th, he's positive for alcohol at a 0.031, and then missed retest early into the morning or early into the evening. Anything you'd like to say on that? Because
Yes.
I see this. Go ahead, sir.
I appreciate that, Your Honor. What I'd like to point out is that he is also on a GPS tether. He's had no violations on that GPS tether since that was put on January or July 25th. He has had some late testing. If you look at the throughout the bond violation report, there's many instances where he's maybe 10 minutes late for a test, but he still tests and he's negative for alcohol. There's a couple where he's an hour or two late, but he tests negative for alcohol. And that's the most common offense that we see throughout there. My client tells me that when he was given the alcohol testing device, that it wasn't, explained to him regarding these retests. He's also had problems with the test actually working. And I emailed over to your office, and hopefully you have a copy of it. I know I went to the prosecutor's office as well, but it was a copy of the notice from the device saying that it was overheating and it's not able to work. That's part of the problems that he was having. He's reached out to community corrections to ask for advice on what to do when he's having these problems. He never received a return call from them. When my client reached out to me, or I reached out to him after with this alcohol reports, he's adamant that he has not consumed any alcohol, but he had used mouthwash that contained alcohol in it. I advised him that that could cause a problem, as well with his medical issues. It could exacerbate that problem and provide a false positive test, which he's saying is what's happening with him. Once I advised my client about this, since it would have been the end of last week when I first found out about it, he hasn't had any negative tests since then. He also had an issue with the charger with those devices. He had to go get another charger so he could keep that. So I know on paper it looks like he has a lot of violations, but it's a lot of the times where he's a little bit late for a test, retest, and he's negative. So what I'd ask is that we would continue on with the testing. He's taking care of the issues that he's had with that. And I believe I just got a message from your office saying that they are printing that now. It was the image.
I have.
Okay, all right, great. So that's something my client sent to me. That's what the readings he would get, and that would be part of the problems of why he had these, late tests in some of these instances. So other than that, he hasn't had any other problems. He's got employment. He's got another job that's upcoming. He's just got a new apartment, which would be part of our motion to amend the bond. So we just ask that you keep him on the home confinement.
Okay, well, two things, and certainly I'll let the people respond. But with reference to the bond violations, even if he consumed, first of all, that's a lot of mouthwash. Number one. Secondly, if the mouthwash contained alcohol, he is apprised at the very beginning when he signs up for the SoberLink device that he is to consume not only just not drink, but he is to not use any products that contain alcohol. So if it is mouthwash, and I'll be honest with you, I don't believe for one darn moment that it is. I think that's a bunch of malarkey, not the word I really want to use. And if he wants a hearing, we'll have a hearing.
I'll have a hearing.
Pardon?
Oh, sorry, you say hearing?
There'd be a hearing on it. I'd set a hearing on this. We'll have a hearing. We'll bring the experts in. We'll bring everybody in regarding this testing.
Okay.
And this problem that he's having, the device, the temperature of the device is too high. It's not necessarily a malfunction of the device. It's something else that he's doing with regard to that machine. So, counsel, do you want a hearing?
We can set a hearing, Your Honor. I believe that's what my client wants to do.
Well, it's just going to be a longer day, but what the heck. I'll adjourn the probable cause conference on this to next week, the 11th, 2025. I set it at 9/8. Well, actually, I might as well just set it at 3 p.m. if I'm going to have a hearing, and a hearing on the bond violation. But at this time, and I really don't need to hear from the people unless you want to tell me something, on the case ending in 1167, I will continue his bond on that case. In the case ending in 5152, the operating while intoxicated, defendant's bond at this time is revoked pending hearing. Defendant's remanded.
Thank you, Your Honor.
Thank you. Court does call the case People versus Ahmed Ajibori.
Good morning, Your Honor, to you and your staff, afternoon, Brian Berry appearing on behalf of Ahmed Al-Jabori.
Is he here?
He's here.
Yes,
Judge.
Your Honor.
State your name, sir.
Ahmed Mohammed Al-Jabori.
Thank you. All right, what are we doing?
We'd like to set this for exam, Judge.
All right. Is all discovery complete?
As far as I can see.
And would people have their witnesses available to 16?
Yeah.
Preliminary examination in person will be set September 16th, 2025, 9 a.m. That will be before Judge Perry.
Judge, I have a competency hearing in the 36th District Court at that time.
Okay, you want a different date?
Please,
Is that what you're telling me?
Yes.
All right. How's the 23rd in the morning looking?
I have a hearing that day as well. I can do the afternoon on the 23rd.
I have to set them in the morning.
Okay,
It's not my docket, so you're gonna get a different judge. They're here in the morning.
okay. Would it have to be is it
Okay.
on Tuesday?
All right, hold on, just hold on. Let's see if we can find something that fits with your schedule.
Thank you, Judge.
September 30th.
I have a hearing on that day as well. I have a trial.
In the morning?
At 9 a.m. and
Are you available in the afternoon?
on the 30th, yes.
Good. Set it for September 30th, 2025. That'll be at 12 noon. Let my office know when you can get here. That is before me.
You know what,
Without
Judge,
objection from the people.
Thank you, Judge.
Will that work? All right.
It does work.
Bond. All right. Bond will continue. Thank you.
Thank you.
Thank you, Your Honor. Have a good day.
You too. Court calls the case, People versus Charles Boyd.
Good afternoon, Your Honor. Attorney Gregory Sheen on behalf of Mr. Boyce, who's present via Zoom. Your Honor, we have reached a resolution in this matter.
Yeah. Mr. Boyce, can you state your name?
Yes, Your Honor. My name is Charles Boyce.
All right, somebody want to clue me in on what this purported resolution is?
Yes, Your Honor. My client did get accepted into sobriety court with Judge Washington. So I know that was a arrangement that we had discussed with the prosecutor's office, that if he did get accepted ahead of time, they would offer this to be a second, which would be a misdemeanor, and then my client would be able to get transferred to 14B.
Your Honor, it looks like defense counsel did email me this morning at 10:56 that his fine had been accepted, so unfortunately.
How come you didn't answer?
I was a little preoccupied.
Were you?
I was.
Oh, yeah, you were here.
I was here.
Okay, that's hard to answer. That's right. There's a lot of cases going on. Okay, yeah, go ahead. I'm sorry.
I haven't had a chance to prepare the paperwork.
Okay, and we need the paperwork prepared because I have to take the plea and then move on. So I'll adjourn this out. Will the 18th work for you, counsel?
That's going to be a little difficult.
I'm going to stop being so nice. It's just too bad. No, go ahead. What?
I'm sorry, Your Honor. I can do the following week.
The 25th?
Yes, Your Honor.
Okay, what the heck?
Thank
September
you.
25th, 2025. It's 9 a.m. It's likely your case will be scheduled in the afternoon. Bond will continue. Thank you.
Thank you.
Thank you, Your Honor.
Court calls the case of the People versus Jack Ritchie.
Good afternoon, Your Honor. For the record, Attorney Russ Donaldson, P number 53660, appear on behalf of Mr. Ritchie. Mr. Ritchie, will you identify yourself, please?
Jack Ritchie.
Your Honor, we'd agree to proceed by Zoom technology today. I discussed this matter with my client. Although there's some potential There's some outstanding discovery. We don't believe it's ever going to be made available. I've explained to my client his right to have a preliminary exam, and he is going to waive his right and proceed over to circuit court, Your Honor. This matter's been adjourned a couple times. Just by way of background information, there are 2 devices that law enforcement have that they're unable to access the information, or alternatively would take a potentially significant amount of time. My client is aware of that outstanding discovery, but he'd like to proceed over to circuit court for further disposition.
All right. Sir, is that correct? You want to waive your right to have a preliminary exam?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
I do.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor. Thank you.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts. Counsel, you acknowledge receipt of the information waive its reading?
We do, Your Honor. Thank you.
And at this time, is your client standing mute?
That is correct.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea on his behalf. Pretrial in this case will take place.
October 23rd at 1:30 with Judge Slip.
October 23rd, 2025, 1:30 before Judge Slay.
Thank you, Your Honor.
Thank you.
Thank you. Your Honor, may I have approach to sign the information?
Bond with its conditions will continue.
Thank you, Your Honor. Are we free to leave?
Yes, you are.
Thank you.
Thank you, sir. Do I have? I don't even know if I have one. I don't have a loose. No, I do. Court calls the case of the people versus Nicholas Smith.
People.
Good afternoon, Your Honor. Robin Kennedy appearing on behalf of Mr. Smith, who is present via Zoom. Mr. Smith, can you please state your name for the record?
Yes, my name is Nick Smith.
All right.
And
What do
Your
we do?
Honor, the sister counsel and I are currently in discussions with regards to potentially resolving this matter. So we're asking for hopefully what will be a final probable cause conference. We have some logistics with the potential for sobriety court, but Mr. Smith is no longer residing in Washtenaw County. So we may need to look in his current county of residence to see if there are any openings and if he can be accepted to a local sobriety court.
All right. I'll adjourn the probable cause conference to September 30th, 2025. That's a Tuesday, 9 a.m.
Excellent. Thank you, Your Honor.
Thank you. Bond will continue with its conditions. Thank you.
Thank you.
sir.
Have a great day.
Court calls the case people versus Jacob Ramsey.
People.
Good afternoon, Your Honor. David Chan, on behalf of Jacob Ramsey, is approaching. Jay, can you please state your name for the record?
Jacob Ramsey. All right. You're requesting an adjournment.
Yeah, Your Honor. There's some some opportunities that have been made available by the prosecutor we'd like to explore. So if we could have 30 days. I'm trying. But it was stuff that I was talking.
30th work for you?
Yes, that would be fine.
Probable cause conference, September 30th, 2025, 9 a.m. Bond continued.
Your Honor, can I address one issue of bond?
He's out now. Yeah, go ahead.
I know.
Have at it. Take your best shot.
He has a diagnosed ISB, and he's been trying he's got a medical marijuana card that he's been treating with since 2008. And he's been trying to tough it out on terms and conditions of bond because he can't use marijuana, but it's become a real problem. And so I had him go to his doctor. He got a letter from his doctor about his use of marijuana, and he's got a medical
marijuana card.
Yes, and I just wanted to make sure that the court was aware that he has talked to his physician. I do have a letter confirming his diagnosis, and that it would be okay for him to go back to using marijuana to treat his ISB.
Your Honor, if he has a valid card, he works on it.
Yeah, I mean, he's got a card.
I just wanted to make sure. It's better to be safe than sorry.
That's true. Did you want me to do something to him?
No.
No?
We like not being incarcerated.
Yeah.
Very fond of that.
Oh, okay. You're just always trying to ruin my day. All right, Bond, we'll continue. Thank you, sir. He's standing up there like, oh my God, Shan, stop. Court calls the case, People versus Adrian Harrison.
Alan Zend on behalf of the people.
Good afternoon, Your Honor. Wonderful to see you. Robert Ellman with and on behalf of Mr. Harrison. Mr. Harrison, can you please state your name for the record?
Adrian Harrison. I'll wait for him to get situated.
Your Honor. No, you're good. Okay.
I'm good. Didn't want to go. All right. Thank you.
Your Honor, I've been in discussions with the people on this matter. Mr. Harrison is currently in treatment. In light of that treatment, we're working on a potential misdemeanor resolution. We just don't have all the details of that squared away yet, so I'd be asking for an adjournment.
Okay, so he's in treatment and
he's an inpatient in Sparrow right now.
Got it. Where is he on the treatment path? I mean, how long? How far?
So, Your Honor, and I did receive information just from Dawn Farm recently. He is actually set to successfully complete the program on September 11th and then move into transitional housing.
Right.
They've found him a place to live. They've also found him employment. And so he is doing everything right now. Anything that we would want of him, he is doing.
And that's correct, Your Honor. Would things possibly go out
October 9th.
that or the 23rd for September?
All right, why don't I do this? Because he's gonna go into housing, let him get himself situated, do what he needs to do then. So I will, in this case, adjourn to October 9th, 2025 at 9.
And Your Honor, if I may address Bond just briefly.
You and Shan, go ahead.
And Your Honor, I will start, unlike Mr. Shan, and say my client is very grateful and happy to be out of custody right now, and he is making the most of his time out of custody. And like I had said, he's doing everything we could want him to do. He's currently on a GPS tether right now. He does report to me that gives him a lot of anxiety and trouble sleeping at night and just issues there. So I would ask that, just based on the positive acts that he's made since he's been released to treatment, that be removed.
I'm not even going to consider it until he gets out of the initial part of the treatment and then someplace into his next thing. It's not that I won't consider it in the future. I'm just not at this juncture. I'm not going to.
Okay. Thank you, Your Honor.
So
Fair
I'll
enough.
deny that request for
Thank you, Your Honor.
bond modification. All right, this bond will continue. Thank you, sir. Court calls case People versus Martina Smith.
Good afternoon, Your Honor. People.
And good afternoon again, Your Honor. Robert Ellman with and on behalf of Ms. Smith, who's approaching. Ms. Smith, can you please state your name?
Martina Smith.
Take your hands out. Yes, Your Honor, after discussions with the people, I believe there's some outstanding discovery in this case that we're waiting on, that I believe they will be sending over to me shortly. I know the people already have it. It was just I guess kind of a filing error.
September 25th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continue. Thank you, ma'am.
Thank you.
You're all set. Okay. Take care. She said here. Oh, she did. Memorable. Court calls the case People versus Winslow Teague.
And Your Honor, this is the last one for me, Robert Ellman, with and on behalf of Mr. Teague.
Quit making promises. Anyway, go ahead.
Your Honor, I've talked to the people. I'll be asking.
Your name, sir?
I'm sorry.
Where's the rest of his pants?
I apologize, Your Honor. I'll make sure he wears pants next time.
Go ahead.
Things I never thought I'd say in court. But Your Honor, I'm glad I can make you smile. I've been talking with the people. We do need a little more time to try to reach a potential resolution, and I believe there may be some outstanding discovery. I'm not 100% sure of that, but for those reasons, I'd be asking for an adjournment.
Probable cause conference without objection during that to September 25th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Thank you, sir.
Our file does show that we sent what we have, August 19th, but I will confer with the defense counsel and see if there's something that he thinks is missing. But that's to get that.
All right.
Thank you, Your Honor. Have a great rest of your day.
You do the same. Court does call the case of the people versus Kaida Matson.
Good afternoon, Your Honor. Michael Vincent, on behalf of Kaida Matson. State your name for the judge.
Kaida Matson.
Thank you.
Your Honor, we're here on a PCC. I'm going to need an adjournment. Apparently, it sounds like a mini police convention when her and her friend dealt with the police. So we need some videos.
Okay.
And I've been told and instructed by Amanda to take whatever date you give and it can be adjusted down the road.
Okay, so I have great alarm that I didn't see her and I understand why.
Yes.
And more importantly, I had great trepidation because you were here alone.
Me
And
too.
I didn't know what I was gonna do with the date. So I got you. So we will do this. Probable cause conference, September 25th, 2025, 9 a.m. Found continued. That's not right for your calendar, Amanda.
Is Miss Benson testing here?
Pardon?
Are you testing here?
I'm testing for Lenawee.
But not here. She's testing twice a week at Lenawee. She's completed an inpatient program. And how long has it been clean now?
41 days.
She's working at it.
Yes. How's it feel?
Feels great.
Yeah. And it just keeps getting better.
It does.
All right. All right.
Thanks.
Yeah.
Thank you.
Thank you, Ms. Quinn. Court calls the case of the people versus James Young.
Judge, I'm Barton Morris. I'm appearing on behalf with the defendant.
All right.
There's an amended information.
Yes. Could you state your name, sir? All right. There is an amended information regarding counts 3 and 4. Count 3 being child sexually abusive material, aggravated possession, and then count 4, computers using a crime to permit with a maximum imprisonment of 10 years or more, but less than 20.
We've received the amended complaint, and I would stand my client mute regarding arraignment.
Standing mute, court will enter a not guilty plea. All right, you're requesting an adjournment for additional discovery.
Correct. As there are new charges, there's additional, obviously, discovery, and the people need additional time to get that to us. They're continuing their investigation. And we've agreed, if it pleases the court, to October 2nd or October 8th.
And that is correct, Your Honor.
Neither one of those. I won't be here October 2nd. The 8th, not a Thursday. I mean, the 9th. Oh, will that work? That's okay. I did that earlier and got yelled at. Okay, she didn't yell. Felt like I was yelled at. Huh. Probable cause conference will be adjourned October 9th, 2025.
And
9 a.m. Yes, sir.
we've agreed that the bond conditions of cellmate remain the same.
Your Honor, I did just want to state for the record that in reference to discovery in this case, I spoke with Detective Sergeant Mike Matthews yesterday. There are over 6 million images that we need to go through in this case, so I'm not sure exactly when that is going to happen throughout the pendency of this case. They did
6 million?
6 million. They do 1,000 every 5 minutes. It's still going to be quite good.
I'm not doing the math. Okay, I'll just take your word for it. All right, well, we'll figure it out. And if it's not near ready, contact my office if we need an additional date or something like that.
Thank you.
Thank you. Bond will continue. Yes, court recalls case of people versus Thompson.
Good afternoon again, Your Honor. Raymond Cook, please.
And again, Assistant Public Defender Jay Bellinger on behalf of Ms. Thompson. Ms. Thompson, can you please state your name for the record?
Joanne Thompson, sir.
All right, we got her test back. She's all negative.
I've been trying. I'm really trying right now. I'm trying to get my life together for my kids with losing my spouse the way I did. I'm really trying. I know I messed up and I'm not afraid of it. I'm sorry I messed up, but I'm really trying right now.
Well, part of the other reason I gave you that opportunity is because Mr. Bellinger convinced me to do so. Because normally I have a very swift way in which I deal with it. But
I
You- so
appreciate,
you-
all right,
well, You thank him, don't thank me.
thank you. I appreciate it more than you will ever know.
Okay, and you're requesting an adjournment on this?
Yes, Your Honor. My understanding as Ms. Thompson previously stated is that she's got the intake for Don Farm's outpatient program on the 10th. So I would be asking for 3-4 weeks after that so we can monitor her progress.
That objection, I'll adjourn this to October 9th,
My birthday.
2025, 9 a.m. Okay,
So hopefully good news.
You
then.
said 9 a.m.
well, I'm not sure.
It'll probably be
Just
late.
call just to be sure.
Well, you can either call the court or your counsel will let you know what time you're set.
Okay, yeah, because I happened to yesterday morning, I called, they were like 9 a.m. and then I got a call later, even like 2 p.m. I'm like, oh, okay.
I didn't answer the phone, right?
No, you did
So
not,
I
so,
can't tell you what happened.
okay, thank you,
All
Your
right.
Honor.
Thank you.
Thank you, you have a good one.
You do the
we're
same. Court does call the case of People versus Devontae Owen.
Good afternoon, Your Honor. Ashley Feltes for the people.
Owen and Jonathan Emmons as well, Your Honor. Thank you. You guys.
Good afternoon, Your Honor. Please, this Honorable Court, Brandon Bird on behalf of Devontae Owens. Mr. Owens, can you please state your full name for the record?
Devontae Owens.
Right.
Your Honor, today defense counsel emailed Mr. Evans and myself a motion and some proposed orders. I am going to request on behalf of the prosecution the full 7 days to respond to those motions, that motion, excuse me, and I understand there may be more coming.
Or
Motions. Mr. Bird and I discussed where this case is headed, and we are set for probable cause conference next week after the arraignment today. But that date likely will not be enough time for all of these things to happen.
so you're potentially objecting to a subpoena dicus secum to a company
Yes, Your Honor.
on what grounds?
Your Honor. First of all, I didn't have all the time to review this because
I understand.
today. MCR 6.001 for scope specifically says that depositions and other discovery proceedings under subchapter 2.300 may not be taken for the purposes of discovery governed by cases governed by this chapter.
There is no subpoena ducis tecum provision in the court rules other than court rule 2.305, which is prohibited by the criminal discovery rules. You cited to 6.5, but that's for post-appellate relief.
You're objecting to his ability to serve a subpoena for discoverable, what could be potentially discoverable and exculpatory information?
Potentially, Your Honor, we would like time to respond in writing.
Okay, yeah, you have time to respond in writing. And if you're correct in that, then I'm going to order the people to produce it, if that's your witness.
Okay, Your Honor. I have
So
not.
that you understand where I will head.
Thank
The
you.
information will be gotten one way or another.
Thank you, Your Honor.
And thank you, Your Honor. Respectfully,
So I'll adjourn the motion out. When are you set for PCC?
we could set this for PCC for October 25th. I know that's pretty,
October 25th?
September 25th. Sorry. September
If you
25th.
said, if you were serious on October, I was going to come off the bench and tackle you. It was just my visceral response was going to be that.
I was a defensive tackle. It's not
I
gonna
just
be.
wanted to make sure what I was hearing.
But if we could set this for September 25th, I do plan on putting in some more motions. This is a lot of discovery in this matter. And before I make any decisions on how we proceed further, I need to speak to my client multiple times and go through every inch of that discovery and put in every motion that I need.
All right. So what I will do is I will adjourn this to September 25th, 2025 I'm going to make it at 3 p.m. and I'll adjourn also your motion to that time.
Thank you, Your Honor.
Will the court conduct the arraignment as to the added counts today?
I will.
Thank you, Your Honor.
You got a copy of the information on this, the new amended complaint.
Yes.
Mr. Burris.
I do got a copy and was able to go over it with my client also, Your Honor.
All right. And as to those counts, does he waive formal reading, stand mute to the added counts 3 and 4?
Yes, Your-
3, 4, 5, 6, and 7.
yes, Your Honor.
All right. And I don't know if I said this, he stands mute to those charges, correct?
Correct, Your Honor.
All right. Court will enter a not guilty plea as to those counts on the defendant's behalf. Counts 3 through 7. Did mute to those counts. All right, so I will adjourn that off. The defendant's bond, is it currently stand at denied?
I think it's currently $750,000 cash, Your Honor.
He's not previously charged with the count 4.
My client,
Then in regard to bond.
no, nothing regards the bond to me, Your Honor.
All right. The court, given that the new charge of homicide over murder is added, the court at this time is going to deny the defendant's bond.
Thank you, Your Honor.
Doing that pursuant to the court rule.
Thank you, Your Honor.
Court does call the case of People versus Adonis Sweat.
Ashley Feltus for the people.
Again, Jonathan Evans on behalf of the people as well.
Good afternoon, Your Honor. Wendy Barnwell, P42505 on behalf of Mr. Adonis Sweat.
Your name, sir?
Adonis Sweat.
All right. Let's do this as to the additional charges, the arraignment on those. Do you waive formal reading of the charges, counts 4 through 7?
Yes, Judge.
All right. And your client stands mute to those charges?
He does.
All right. Court will enter a not guilty plea on his behalf. 4 through 7. Stood mute. All right. What are we doing with this case?
And I know that we have a PCC on September 11th. And as counsel said, the co-counsel said, I don't know. I mean, I have a bunch of discovery and more to be gotten because I have to take down an independent device because there's so much memory that needs to, they can't send it the normal way through evidence.com. So I'll ask you the September 25th date in the morning.
Just to keep them together, Your Honor.
I will adjourn probable, well, I'll have to do it in the afternoon because I've got motions coming up, counsel.
Okay. So that would mean that September 11th is off?
Yes, I'll cancel the September 11th, move it to September 25th. I don't know whether or not you're joining in the co-counsel's motions or not.
Haven't seen a single motion. Nobody has served me with a copy.
I'm sure they'll all be happy to send those to you. So I will cancel the September 11th PCC. I will now set it for September 25th, 2025 at 3 p.m. All right. Given anything regarding bond, the court is inclined to deny the defendant's bond at this time with the added count 4 of homicide. Anything you wish to say, Ms. Barnwell?
No, Judge, I'll address it on September 25th. Thank you.
So at this time, defendant's bond is ordered denied. Pursuant to the court rule. Anything further?
No, Your Honor, thank you.
All right, thank you. Court does call the case of the People versus Richard Halstead.
Good afternoon, Your Honor.
Good afternoon, Your Honor. Brandon Bird on behalf of Richard Halstead. He's not, Your Honor. Respectfully, my client, my client indicated to me that his car broke down. Now, I know he has been in contact with me multiple times. He's been staying on top of this case. We're just asking for the grace and mercy of this court to allow my client a second chance.
What is that?
It's you, Your Honor.
What's me? Grace and mercy?
Grace and
Why are
mercy.
you why are you asking me to give you something I have? I don't have. He said his car broke down?
He did. He called me, said his truck broke down. He wasn't about to be able to show, but like I did say, he has.
Oh, he had a truck.
Truck.
It was probably a Chevy.
For repair day.
Let's go guess.
Yep.
No, I'm kidding. Here's what I'll do. I'll issue a bench warrant for defendant's failure to appear. 10,000 cash surety. I will not have that bench warrant issue until the 9th. And if you get to the court information, we will just cancel the warrant, reset a date.
Thank you, Your Honor.
Court does call the case of the people versus Edward Reed.
Alexander on behalf of the people.
Good afternoon, Your Honor. Constable based on behalf of Mr. Edward Reed, who is approaching.
Your name, sir?
Edward Reed.
All right.
What did we time set for a violation hearing as well as a probable cause conference? As to the violation hearing, my client is going to be admitting, Your Honor. He wishes to take full responsibility and move forward with his case. He's had a lot of time to think about it. He's had more clarity. He's been in custody for about 30 days now after bonding out. So he wants to move in the right direction, Your Honor.
Okay. Court will accept the admission to the violation. All right.
As to the probable cause conference, Your Honor, my client is waiving. There's no offer at this time. So my client is waiving to seek an offer at circuit court.
He served 30 days already.
That's correct. Over 30 days.
Over.
Yes.
Do we know how many?
35.
35. So you're waiving your right to have a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, Your Honor.
You understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive the rent.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over circuit court on count 1 with 2 following.
Thank you, Your Honor. We waive your formal readings, standing you to the charges.
Defendant have a waived formal reading, stand you. Court will enter a not guilty plea as to both counts. Pretrial on this matter will be set for
September 18th at 1:30 with Judge Slay.
September 18th, 2025, 1:30 before Judge Slay. With reference to the violations, I'm going to sentence the defendant to 60 days, Washtenaw County Jail. I'll give him credit for the 35. He's to serve the balance. Then his previous bond will be reinstated.
Thank you, Your Honor.
Thank you, Your Honor.
You understand that, sir?
Yes, sir. Yes, Your Honor.
And that was before Judge Slay.
Yes.
I'll just tell you, if you want to mess up, go right ahead. Think I'm bad. All right.
Thank you, Your Honor.
Thanks, Your Honor.
Your Honor, may I request the second information?
Yes, I think I have it. Court does call the case, people versus Derek Lovely.
And on behalf of the.
Yes, Your Honor. Brandon Bird on behalf of Derek Lovely. Mr. Lovely, can you please step to the podium and state your full name for the record?
Derek Lovely.
What are we doing?
I respectfully like to set this matter for exam, Your Honor.
Discovery is complete.
As far as I know, Your Honor.
People will have their witnesses available the 16th.
We'll do our best, Your Honor.
Preliminary examination will be set September 16th, 2025. 9 a.m. That is before Judge Washington. Bond in this case will continue. Thank you, sir.
Thank you, Your Honor. You and Your Honor, great day.
You do the same. Court does call the case of the people versus Kanaya Johnson.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon, Your Honor. Wendy Barnwell, P42505, on behalf of Miss Kanaya Johnson.
All right. And I do have before me a plea form. Is that what we're doing today?
Yes, Judge.
All right. Plea form indicates that the defendant will be pleading guilty to an added count 2 of disturbing the peace, 90-day offense. Upon a successful plea, count 1 would be dismissed. And there is an agreement that she agrees to forfeit the taser to the EMU Police Department. And there is an agreement that the prosecutor will recommend a sentence that the defendant be sentenced under HIDA. That's the court's full understanding of the agreement. Is all of that correct?
Yes, Your Honor.
That is correct, Your Honor.
All right. I don't have a signed advice, so I'm not going to worry about it at this point. We'll figure it out when I go through the rights. All right, ma'am, if you could please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name for the record, please.
Kanaya Johnson.
All right, you can put your hand down. Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. Do you understand that?
Yes.
Do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand that, ma'am?
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense, ma'am?
Yes.
Ma'am, on date of December 12th, 2024, at 421 Putnam Hall, EMU campus, what'd you do on that date that makes you think that you're guilty of this offense?
Well, the taser incident, it was my taser, like I owned it. So I'm gonna
Did you possess a taser? Did
Did
you
I
possess a taser?
did I
Yes
use it?
or no? Did you possess is the word. Did you possess a taser? Meaning have it.
Yes, it was mine. yeah.
Okay. I think that's the factual basis, Judge.
All right, and somehow or another, the people at EMU discovered that you had the taser?
I'm sorry, what was the question?
All right, somehow or another, it became known that you had the taser by somebody at EMU, correct?
Yes, I owned the taser.
It's a yes or no. That's how it's yes or no.
Yeah,
Don't add to it.
Yes.
Don't
All right.
add.
Yes. Okay. And upon them finding out that you had the taser, that in some way disturbed the peace and repose of the immediate area surrounding you. Is that correct?
Correct.
Okay. Ma'am, I have to advise you that if I do accept your plea, And between the time of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, any sentence evaluation or recommendation, the court would no longer be bound by, and you would not be able to set aside your plea. You understand that, ma'am?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have caused this plea to occur?
None from the people.
No, Judge. Sorry, no, Judge, sorry.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
September 24th at 10 a.m. with Judge Barr.
September 24th, 2025, 10 a.m. before Judge Barr. Bond will continue.